I understand this. Whoa, but. Commonwealth versus Dalton Birdwell. There's some interpreters here. Are they for transporting? Are the interpreters for transporting people? Are the interpreters for transporting people?
There's one that is, and I think one that is.
Okay, let's turn this podium around here.
The wires on there, we don't. The last time I pulled this stuff. I didn't pay any attention to it, but you, thank you.
Commonwealth Kentucky versus Dalton Birdwell, 24 CR 0058. Are you Dalton Birdwell?
Yes, ma'am. Yes, sir.
Okay. Good morning.
Morning.
Were you born in 1998?
Yes, sir.
Last four digits, social security number 5368.
Yeah.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to burglary in the third degree, the defendant shall receive a sentence of 5 years. On a plea of theft and lawful taking disposition over 10,000, he shall receive a sentence of 10 years. On a plea of guilty of facilitation of criminal syndicate, he shall receive 5 years. The 2 5-year sentence shall run concurrently for a total of 5 years. And this 5-year sentence in a 10-year sentence shall run consecutively for a total of 15 years. The 15-year sentences shall be concurrent to indictment number 22 CR 0051. And there was a restitution agreement in here too. Is that right, Mr. Stockton?
No, there is not a restitution agreement on Mr. Birdwell.
All the other defendants.
The other defendants,
Yes,
okay.
but not on him.
Okay, well, that was unclear to me. Thank you for clearing that up. Okay, thank you very much. Yeah, I'm gonna waive the court costs since you're gonna be in for a while.
Thank you, Your Honor.
Yeah. Claude Kevin. Claude Kevin.
Okay.
Please remind me to send that judge down there in Louisiana. Thank you note or gift. Gary Emberton is on deck. Okay, Gary Emberton is next. Commonwealth Kentucky versus Claude Kevin. Are you Claude Kevin?
Yes, sir.
Good morning.
Good morning.
Are you born in 1998?
Yes, sir.
Last four digits, social security number 0475.
Yes, sir.
You're here on 24 CR 0082 for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Judge, it is. There is one correction with regard to his criminal history that I will inform probation. There is one case that is labeled as pending out of Allen County. It has been dismissed.
What's the number on that?
Judge, it is 24T 549.
Okay, did you get that?
Yes, sir.
Okay. Claude pleaded guilty to bribery of a public servant. 2 counts. Defendant shall receive a sentence of 7 years on each count to run concurrently for a total of 7 years, probated for 5 years supervised. He shall enter and complete the Monroe County Specialty Court. Has he been voted into the specialty court yet?
Yes.
Okay, so he can get when does orientation take place? Okay, well, we'll let him out as soon as the orientation can be scheduled.
And Judge, for the court's knowledge, he's being housed in the Simpson County Jail.
Wonder why that is. So you got charges in Simpson County?
No,
Did you have trouble in the Barron County Jail?
yes.
Okay. Once you find out when the orientation will be. Where are you gonna live when you get out?
I'm supposed to go back to Bowling Green, to the halfway house that I was living in. But until then, I'm gonna try to go to my father's so that way I can get orientation and meet with probation and have it.
Drug court gonna be here or Bowling
He'll
Green?
have to stay here until if and when he's transferred.
Right,
Yeah, talk to Gerald about that.
okay.
They'll have to approve it.
She's transferred to where?
To wherever, if it's Bowling Green or wherever, he may get transferred and he may not. I said if and when, so that's up to the drug.
Yeah, I can stay in Monroe County till then.
Oh, you mean transferred in the drug court, one drug court to another?
That's
That's
correct, yes.
I had the jail in my mind,
Oh,
you know.
yeah.
Okay, well, we'll just go ahead and I'm gonna waive the court costs in this one too, since it's very significant incarceration involved in it. Okay, well, you'll,
They always email me when they're ready for
okay,
orientation.
when you get oriented, your attorney will be contacted and you'll be able to let out the day of your orientation, but one of the things they're gonna demand is that you have someplace to live, isn't that right?
Yes.
Designated place to live, so you need to get that, doesn't need to be iffy, you need to get locked down.
I've got a place to
Well, I
go.
know, but when somebody asks you, you need to tell them where it is. I might go here, I might do that, I might do that. You just, I'm gonna go to my dad's and address is so-and-so Emberton Road or something, okay? Okay, thank you very much.
Thank you.
Gary Emberton. Seth Graves on deck. Commonwealth versus Gary Emberton, 22 CR 0062. Are you Gary Emberton?
Yes, yes,
Good,
sir.
good morning, Mr. Emberton. Were you
Good
born in 1961?
Yes,
Last 4 digits, social security number 6926.
yes.
We're here on a pretrial diversion revocation. You want to move to your left a little bit, Mr. Stockton, you'll come around.
Yes, Mr. Emberton has a 5-year sentence for traffic controlled substance first degree. He was arrested here in Monroe County for DUI and no insurance on November the 12th, 24. He pled guilty to DUI second.
Your Honor, we had a hearing on this, I believe, back in October, before he had been convicted of the charges. The
You're
court
gonna
had
have to speak up.
Your Honor, we had a hearing on the DUI back, I believe, in October before he was convicted of the charge. The court stated at that time that you were going to wait until there was either a conviction or acquittal to make a decision on the pretrial diversion. He has been convicted at this point, but he has been in custody since, I believe, September the 21st of this year, so almost 3 months at this point in time. So we would ask the court to allow him to remain on his pretrial diversion and have him assessed for drug court.
Well, I don't care to have him assessed for drug court, but I'm gonna revoke the pretrial diversion. And at sentencing, I'll take a look to see what the deal is.
And the Commonwealth's position probably should be shopped at in drug court.
Yeah,
That's gonna be my.
we'll go ahead and order a pre-sentence investigation report to be done and he'll be brought back here on January the 16th for sentencing. He'll have a significant amount of time at that point. So we'll either take a look at it at that juncture or 30 days after that, we could take a look at a shock probation.
Thank you, Your Honor.
Thank you.
Yeah. Seth Graves. Commonwealth versus Seth Graves. 24 CR 0075. Are you Seth Graves?
Yes, Your Honor.
Yeah, good morning. Were you born in 1988? You born in 1988?
Yes.
Last 4 digits, social security 4888. You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
On a plea of guilty to burglary in the third degree and persistent felony offender, the defendant shall receive a sentence of 10 years. On a plea of wanton endangerment, first degree persistent felony offender, he shall receive a sentence of 10 years. However, the two 10-year sentences shall run concurrently for a total of 10 years, probated for 5 years supervised. The defendant shall enter complete dual diagnosis treatment schedule under DPA. And what's the deal on this, Mr. Stockton?
Part of our agreement was he'd receive long-term treatment for substance abuse. He'd also receive treatment for any mental issues that he may have. And I'm sorry, Ms. Hill's got him forgive, it's not Spark, it's
Hope Haven.
Hope Haven, where she's got him lined up to go, and that makes the approval of the Commonwealth. It does.
What was the wanton endangerment?
He was in the local service station. He was shoplifting. One of the employees pursued him and he drew a knife on the employee.
That's a good way to get killed.
It is.
Go to a gunfight with a knife one of these days. So I'll go ahead and agree to what you agreed to. I'll go ahead and go with it.
Thank you.
The remaining incarcerated according to the bed date.
Your Honor, we do have a bed day and an order for release if the court would be willing to sign.
Who's gonna transport him?
The rehab facility has their own transportation staff. It's direct door to door.
Okay. Court cost is gonna be waived.
Thank you, Your Honor.
Jared Hale. Jared Hale. Commonwealth versus Jared Hale, 24 CR 0092 and 24 CR 0089. Are you Jared Hale?
Yes, sir.
Good morning.
More.
You were born in 1984.
Yes, sir.
Last four digits, social security number 9494.
Yes,
You're
sir.
here for arraignment on one charge. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with burglary in the third degree, 2 counts, theft, unlawful taking or disposition, disorderly conduct, 2nd degree, criminal trespass, 3rd degree. You understand what those charges are?
Yes, sir.
Okay, you acknowledge the identity of your client, receive the indictment, waive formal reading arraignment, enter plea not guilty, reserving all pretrial motion.
Yes, Your
I'm
Honor.
signing a reciprocal discovery order, sir, that requires the Commonwealth to give you certain information that they have concerning your case. And probably give you a plea offer. The other case you hear it on is 24 CR 0089. What's your negotiation date?
January the 3rd, 9
Negotiation date at what time?
o'clock.
January 3rd at 9 AM. You'll be here for negotiation, and the next court date, January 16th. 9 AM, both of them are conditions of bond. What is this gentleman's bond?
Hang on, phone is no longer on me. Your Honor, I'm showing on the 89 case, it's 25,000 surety, Your Honor, and on the 92 case, 10,000 cash.
Okay, well, if you want to take a look at the bond, you'll need to file a motion, okay?
Yes, Your Honor. Thank you.
Dustin Jesse. Commonwealth versus Dustin Jesse. 24 CR 006. Are you Dustin Jesse? Good morning. Were you born in 1991?
Yes, sir.
Last four digits, social security number 0707.
Yes, sir.
We're here on 24 CR 006 for a pretrial conference. What does the Commonwealth have to say?
We have a felony plea now.
And Judge, just for the court's knowledge, the felony plea will be on 24 CR 99, which is going to be an information by indictment. Indictment by information.
Motion's been tendered, which says you wish to enter a guilty plea under the charge that you've been charged by information. Is that correct?
Sure.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Approved.
Are you the same person that just was identified in 24 CR 006 and 24 CR 0084?
Yes, sir.
Yeah, is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept this plea, I need to know you thoroughly understand those rights. I'm going to ask them to you, and at the end, I'm going to ask you to understand it, okay? Anytime you don't, stop, step away, talk to your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of charge. Unless you understand that by entering a guilty plea today, you waive those rights. You understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting your recommendation, I will wait 3 cents investigation report. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that? Mr. Stockton, will you come around and tell us what the recommendation of the Commonwealth is?
Yes, Your Honor.
On plea of guilty on the information indictment to tampering with physical evidence and persistent felony offender second degree, Mr. Jesse would receive a sentence of 6 years, probated for 5 years, supervised. That sentence will run consecutively to Monroe Indictment 23 CR 10. He'll enter and complete a long-term treatment facility determined by DPA and approved by the Commonwealth, and all evidence in this case will be destroyed.
Is that your understanding of the agreement?
Yes, sir.
Are you pleading guilty because you did commit the acts charged?
I'm pleading guilty because, yes, yes.
He said, are you pleading?
You do so of your own free will?
Oh, yeah.
You do so of your own free will?
Yes, ma'am.
Knowing your constitutional rights, are you willing to waive those rights and allow the court to fix your punishment?
Sure.
Is that your signature on the document?
Yes, sir.
I'll accept the agreement, order pre-sentence investigation, agreement, probation, parole. Sentencing will be on January the 16th. Okay.
That should, that, I report that.
Conception Lopez.
Your Honor,
interpret.
Melanie Lopez for the interpreting.
Okay, we are both interpreters. Raise your right hand, please. Solemnly swear or affirm that you're qualified to interpret proceedings in the courts of justice, Commonwealth of Kentucky. You do so faithfully to the best of your ability. Both of you did it? Okay, thank you very much. Commonwealth of Kentucky versus Conception Lopez.
Conception Lopez.
Are you Conception Lopez?
Is he?
Yes, sir.
Were you born in 1977?
En 1977. Yes, sir.
You don't have a social security number, is that correct?
No.
We're here on 24 CR 0084. For a pretrial conference. What's the Commonwealth have to say?
We have a felony plea, Your Honor.
Okay. Sir, a motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
That's all one. No,
Is
no.
this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified by name and birth date and 24 CR 0084.
Apoyo el mismo nombre y fecha de nacimiento del caso 24 Ajá.
Is your judgment impaired in any way today?
Cualquier cosa que está impidiendo su capacidad de pensar. No, everything is good.
Have you discussed the charges with your attorney and are you satisfied with her advice?
¿Está satisfecho con su consejo?
Sí.
Yes.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Contra. ¿Siente que está cabalmente informado sobre su caso? Ajá.
You understand that you do not have to enter a guilty plea today.
No tiene que declararse culpable el día de hoy, ¿verdad? Ajá.
You have certain rights under the Kentucky and United States Constitution.
Según la Constitución de los Estados Unidos y el Estado de Kentucky.
I'm going to go over those rights and at the end, I'm going to ask you if you understand them.
Y al final le voy a preguntar si usted entiende.
You have a right not to testify against yourself. No one can make you say anything.
Nadie puede obligar a hacer ninguna declaración en pleno los estados.
You have a right to speedy trial by jury.
Sin demora, por jurado,
You have a right to be represented by counsel at your jury trial.
presentado por un abogado durante su juicio.
You have a right to confront and cross-examine all witnesses called to testify against you.
Testimonio en su contra,
You have the right to produce evidence,
de presentar pruebas,
to call witnesses in your favor, to appeal this matter to higher court if you lose,
de apelar su
and to
caso,
require the Commonwealth to prove beyond a reasonable doubt
y obligar a la fiscalía a comprobar más allá de una duda razonable
that you are guilty of the charges against you.
que usted es culpable de lo que se le acusa.
You understand,
¿Entiende?
by entering a guilty plea, you give up those rights.
Estarse culpable, eso significa que estará renunciando a todos aquellos derechos constitucionales.
Now, I may consider the Commonwealth's recommendation
Entiende que yo puedo considerar la
that I may
recomendación
apply
de
any
la
range of sentence provided by law.
pero yo tengo derecho de imponer cualquier condena que cae dentro de la pena mínima y máxima prescrita por ley.
Prior to accepting any recommendation,
Antes de aceptar,
I will await the pre-sentence investigation report from probation and parole.
voy a esperar hasta ver el informe precondenatorio.
In the event that I do not accept the recommendation and decide to impose a harsher sentence,
Una condena más severa
you have the right to withdraw your plea agreement
de retirar su declaración de culpable
and proceed to trial.
y proceder a un juicio.
Do you understand that?
¿Entiende todo eso?
Sí.
Yes.
Okay. Mr. Stockton, y'all move to your left a little bit. Mr. Stockton. What is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance first degree, the defendant will receive a sentence of 1 year to serve. That will run consecutively to Cumberland County case number 23 CR 64. The defendant shall receive credit for time served. The Commonwealth opposes probation and shock probation.
Come back forward here. Is that what you agreed to, sir?
¿Eso fue el acuerdo de lo cual usted se acordó, señor? Ajá.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
De hecho, es culpable de lo que se le acusa en el documento acusatorio.
Yeah,
Yes.
are you doing it so of your own free will?
¿Lo está haciendo voluntariamente?
Así es.
That's correct.
No, the constitutional rights I've explained to you, is it still your desire to enter a plea?
Derechos constitucionales, los cuales le he explicado anteriormente, ¿es su deseo proseguir con una declaración de culpable hoy?
You understand that
Yes, I
after the,
plead guilty.
okay, do you understand after entering a plea guilty, any future felony convictions could be enhanced as far as range of penalty?
Delito mayor, las penas aumentarán. Ajá.
Okay, is that your signature on the
¿Esa
document?
es su firma aquí en el documento? That's correct, sir.
I'll accept the agreement, order pre-sentence investigation report to be done by
Voy a mandar a
probation and
que se
parole
haga una Investigación para preparar el informe precondenatorio.
And schedule a sentencing on January the 16th.
Lo vamos a poner el día 16 de enero en la lista para la audiencia de la imposición de la pena, ¿sí?
Yeah, I'm gonna waive the court costs.
Y voy a dispensar con ponerle el tener que pagar las tasas judiciales.
Okay, thank you.
Thank you, John.
Gracias.
Joseph Martis.
I believe that there is someone else that I needed.
Yeah, let me go down through here. We have another case that requires an interpreter here. Somebody look down the docket.
Yeah.
Where is he located physically? Okay, we'll call him next. Yeah. Commonwealth versus Joseph Martis,
Is there any other than?
24 CR 0081. Are you Joseph Martis? Good morning. Were you born in 1985?
Yes, sir.
Last four digits, social security number 9135.
Yes, sir.
You're here today for sentencing. You had an opportunity to read the pre-sentence investigation report done by probation and parole.
Yes, sir.
Judge, there is one correction that needs to be made. Mr. Martis has obtained his GED.
You catch that?
It's just right.
Yeah. I'm glad you had to take a GED test rather than me, because I don't know whether I could pass it now or not, so. You okay on the math?
Yeah.
Yeah. Okay, the defendant, upon a plea of guilty to fourth degree assault, domestic violence, he shall receive a sentence of 5 years, probated for 5 years. He shall enter and complete anger management classes in complete long-term treatment facility determined, scheduled by DPA as agreed upon by the Commonwealth. He shall remain incarcerated until the morning of the bed date. You haven't a bed date yet?
Yes, Your Honor, I also have a proposed order for the court. The bed would be at Spark, and it would be for Monday. And I provided a copy to the Commonwealth.
Now, explain to me, Mr. Stockton, what happened here.
You give me the final point.
This is some domestic violence.
It is, Your Honor. It is a domestic violence call. Officer responded and the victim stated that her husband, Joseph Martis, had physically grabbed her and shoved her repeatedly and shoved her out the door, causing red marks on her arms and shoulder area. He then began throwing items in the residence and breaking them. It was witnessed by someone else who corroborated her story. There was 3 previous convictions of assault with the same individual. Of course, it's the same song, same verse. The victim doesn't want to pursue the charges or wants Mr. Martis back in the home. So that's one of the reasons for the plea, to try to get him some long-term treatment and get these issues resolved and put him on probation and see if they can get along, if they ultimately
Yeah,
reconcile.
Mr. Martis, I'm gonna go along with this. But I do not want to see you back up here again. If you get to the point, even after this anger management, where it just takes over you, you can't keep from doing it, you need to get the heck out of there. Cause I believe everybody can change, but you have a repeated history of something going on between the two of you, and I don't want it to happen again. Are we?
Yes, sir.
You know, cause you kind of lose it like that, push somebody and not intentionally meaning to hurt them or whatever, they fall down, hit their head. It's a bad thing. Okay? So I'll go ahead and sign this. Garrett Rush, court costs, I'm gonna chart, what are the court costs this case? $215, I'll let you pay it $30 a month, 30 days after you get out, okay? Okay, let's go down and get the other individual that needed the interpreter that's out of custody.
Jose Keo, Your Honor.
I don't see him here. I know, but I don't see him. I don't see him.
He's supposed to.
Okay. You got a file on him? No, the doc. Makes me feel somewhat better that I couldn't find it. He's not on there. So. You're still under oath, Madam Interpreter?
Sure.
Okay. Commonwealth of Kentucky versus Jose
Aquí contra Jose.
Quijano.
Quijano.
Quijano. Quijano.
Yes, sir.
Okay, are you Jose Quijano?
Jose Quijano.
Sí.
Yes.
What's your year of birth?
¿Cuál es el año de nacimiento?
Septiembre, el 1 de septiembre de 1984.
September 1st, 1984.
You do not have a social security number?
¿Usted no tiene número de seguro social? No.
Yeah, there's a letter in the file. Have you seen the letter that,
Yeah, and I'll.
¿Ya ha visto esta carta? Sí.
yeah.
Y la gente también la ha visto.
What do you want to do in this case?
He's ready to enter pretrial diversion.
Él está listo para una alternativa.
Motion's been tendered, sir, that says you wish to enter a guilty plea today. Is that correct?
Se me ha presentado un pedimento hoy, señor, diciendo que usted desea hacer una declaración de culpable, ¿cierto?
Are you currently under the influence of drugs or alcohol?
¿Está en ese momento bajo efectos de drogas o alcohol?
No.
No.
Is this plea freely and voluntarily given?
¿Esa declaración se ha hecho voluntariamente?
Yeah, are you the same,
Yes.
are you the same person
¿Es usted la
named in
misma
indictment
persona
number
nombrada
24
en el
CR
documento acusatorio
00031?
24CR00031?
Sí.
Yes.
Is your judgment impaired today in any way?
¿Hay algo que impide su capacidad de pensar el día de hoy?
No, todavía.
No, everything's good.
Can I have 1 second, Judge?
¿Puedo
He
tener
didn't
un
answer one
momento,
question and I
su
need to see
señoría?
what,
Él no le contestó una de las
What
preguntas.
didn't
Y
he
yo
answer?
necesito, ¿qué fue lo que no
that he's ready to enter a
contestó?
plea today.
Que si estaba listo para declararse culpable hoy.
Oh, sí.
Oh, yes,
I'm sorry.
lo siento.
Have you discussed these matters with your attorney and are you satisfied with his
Con
advice?
tu abogado y está satisfecho con el consejo de él?
Sí.
Yes.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed about your case?
¿Alguien en su contra siente que está cabalmente informado sobre su caso?
Pues
You have certain rights under the
Your
Kentucky.
Honor, the interpreter didn't interpret the response yet.
Go ahead.
Adelante.
Pues mi esposa leyó todo y ella me explicó todo y pues no sé, dice que está bien.
Well, my wife read everything and she explained everything to me and well, she told me it was good, so.
I met with him yesterday, Judge,
Yo
explained
estuve con
everything.
él
I thought he had a
ayer,
full
hoy.
understanding.
Yo le expliqué todo. Yo pensé
If he
que
doesn't,
él entendía
I don't know.
todo. Si él no entiende.
Were you able
no
to
sé.
communicate with him
¿Usted
with
pudo
your
comunicarse
Spanish
con él en
situation?
español?
I felt
Ok.
we were able to
Yo pensé que
communicate
sí nos
everything
estábamos comunicando
well. I thought he
bien.
understood
Yo
everything.
pensé que él sí entendía.
O sea, me explicó mi esposa y pues dice ella que está bien, pues sí, entonces está bien.
I mean, my wife explained everything to me and she said that everything is good. It's fine.
Pero cuando yo hablo contigo en mi oficina ayer, ¿tú no puedes entender a todos o no?
No, whenever she read it, and she starts playing me more or something.
Okay. Pero tú entiendes todos en mi oficina?
Sí.
Okay. He said he understood everything in the office and then she
Él
read
dijo
it
que
to
él
him
entendió
and
todo
explained
cuando
it to
hablamos en la
him, I
oficina.
guess, further.
Y luego
I
ella le
don't
leyó
know.
todo y le explicó
But I
más,
do know
pero
and
yo
can
lo
say
que sí sé
that
y
this is a
puedo
plea that
constar
we've
es
worked
que
on
esa es
for a
una
long time.
declaración
And I am as
que
sure about
hemos
him
estado
wanting this as I
negociando
am
por
anything
mucho
there is
tiempo
on the
y
earth.
estoy lo más seguro de que
Because
él
we've
sí
done a lot
quiere
to
aceptar
change
esa
this. I've had
oferta
many
que cualquier
communications
otra
with Mr.
cosa en
Stockton
el
and my
mundo,
client
porque
about
hemos
this
hecho
plea.
muchísima
And
negociación con el señor
there's,
Stockton
I don't
y
know,
con mi cliente para llegar a este acuerdo, así que no sé.
You understand that you do not
Usted
have to enter a guilty plea today.
no tiene que declararse culpable el día de hoy, ¿verdad?
No, pues, o sea, es la única oferta que me dieron ahorita, entonces, pues yo pienso que sí.
No, but this is the only offer that I have, and so I do think yes.
You have certain rights under the
Usted tiene
Kentucky and
ciertos
United
derechos
States Constitution.
constitucionales bajo la Constitución de los Estados Unidos y del Estado de Kentucky.
Before I can accept a plea, I
Antes de
need to know you
poder
understand
aceptar una
those rights.
declaración de culpable, necesito confirmar que usted entiende cuáles son sus derechos constitucionales, ¿sí? Ajá.
You have a right not to testify against yourself. No one can make you say anything.
Sí mismo. Nadie le puede obligar a hacer ninguna declaración aquí.
You have a right to speedy trial by jury,
O a un juicio sin demora por jurado.
to be represented by
Usted tiene
counsel at your
derecho a
jury
ser
trial,
representado por un abogado si va al juicio.
to confront and cross-examine all witnesses called to testify
Y
against you,
enterarse con cualquier testigo que viene a dar testimonio en su contra,
to produce evidence,
de presentar pruebas para su defensa,
to call witnesses in your favor.
presentar testigos para su
No,
defensa.
pero o sea, ya habíamos quedado con esto, pues. O sea, ya iba a tomar el cargo yo.
Yes, but we had already agreed on this, that I was going to accept the charges.
Just tell him that I have to explain the rights to him to make sure that he says
Tengo
on the
la
record.
obligación de explicarle a cada persona cuáles son sus derechos
Ok.
constitucionales y usted luego tiene que constar que sí entiende cuáles son sus derechos. Okay,
He has a right to call witnesses in his favor
presentar testigos para su defensa.
and appeal this matter to a higher court if he
Tiene
loses.
que apelar su caso a un tribunal superior en caso de que perdiera un juicio.
The right to require the Commonwealth to prove
Derecho
beyond a
de
reasonable
obligar a la
doubt
fiscalía a comprobar más
that you're
allá
guilty
de una duda
charges.
razonable que usted es culpable.
Do you understand that by entering this pretrial diversion guilty plea,
Si usted acepta el acuerdo de la condena alternativa hoy,
you give up those
eso
rights?
significa que usted estará renunciando los derechos constitucionales.
I will consider the Commonwealth's
La
recommendation,
recomendación de la fiscalía,
but if I do not accept it and decide to give you a harsher sentence,
acepto la recomendación del fiscal y decido imponer una condena más severa,
you have the right to withdraw
usted
this
tendría
plea
derecho de retirar su declaración de culpable, ¿sí?
and proceed to trial.
Ok, y proceder al juicio.
Okay, I have some qualifying questions.
Tengo unas preguntas para calificar.
Have you had a pretrial diversion in the last 5 years?
En los últimos 5 años, ¿ha entrado usted en un acuerdo para una condena alternativa?
No,
No.
Have you had any felonies in the past 10
En
years?
los últimos 10 años, ¿ha sido condenado por cualquier delito mayor?
no,
No.
You understand that if you fully
Entiende
complete the
que si
diversion, the
usted
charges will be
cumple
dismissed.
con todas las condiciones de esta condena alternativa, al final del plazo de tiempo, el cargo será completamente desechado.
And you can get your record
Y
expunged.
usted puede pedir que sea borrado de su expediente penal. Ya.
You understand that if you do not successfully
Entiende que en
complete the
caso de
diversion
que usted
program,
no cumple con todas las condiciones de este acuerdo,
that the court will bring you back in and schedule a
Yes.
sentencing after looking at
le
a
va a
pre-sentence
traer de
investigation
nuevo
report.
aquí al juzgado y le va a imponer la condena luego de leer el informe precondenatorio.
Mr. Stockton, what is the Commonwealth's recommendation?
¿Cuál es la recomendación del fiscal?
On a plea of guilty, the information indictment number 24 CR 98 on the charge of wanton endangerment first degree. The defendant shall receive a sentence of 5 years, serve 6 months on home incarceration, balance pretrial diverted for 5 years, supervised. He'll pay a fine of $500 in cost. Write 2 apology letters, which he has completed. On case number 24 CR 31, he will plead guilty to operating a motor vehicle under the influence, first offense, pay a $200 fine and cost. Upon a plea of guilty in 24 CR 31 to terroristic threatening, he shall serve a sentence of 30 days home incarceration. The 30 days and 6 months shall run concurrently for a total of 180 days. He'll receive credit for time served, maintain gainful employment, and pay court costs at the discretion of the court.
There's an error in that paperwork. Yeah, that one, that didn't, our tax changed 180 other than that. Get me to do that now.
Sí,
Is that what you agreed to, sir?
eso fue lo que usted acordó, señor.
Sí,
Yes.
Are you pleading guilty because you did commit the acts charged in the information?
De hecho, usted es culpable de lo que se le acuse en el documento acusatorio.
sí,
Are you doing
Yes.
so of your own free will?
¿Lo está haciendo voluntariamente?
sí,
Yes.
Knowing your constitutional rights to explain to us, it's still your desire to give up these rights, but able to plead guilty to charges
Derechos constitucionales, todavía es su deseo renunciar
and to allow the
a los
court to
derechos
fix the punishment.
constitucionales y declararse culpable.
no,
No,
no, like, si me declaro culpable.
like I am pleading guilty.
He has to waive his rights
Usted tiene que decir que renuncia a sus derechos
to allow me to enter
constitucionales
the judgment.
a fin de poder declararse culpable.
Sí,
Yes.
Okay, is that your signature on the
¿Esa es su
document?
firma aquí en el documento?
sí,
Yes.
I'll accept the agreement, sign the diversion order. What are the court costs in
Voy
this
a
case?
emitir una orden para la condena alternativa.
No.
665.
What?
665.
$665 fines and court costs?
Pagar un total de multas y tasas judiciales de
You need some time to pay that.
$665. ¿Necesita tiempo para pagarlo?
sí,
Yes.
Okay, you pay it at $60 a
Puede
month.
pagar cada mes $60, ¿sí?
Your first payment due
Su
30
primer
days from
pago
today.
lo tendrá que haber hecho de hoy en 30 días, ¿sí?
sí, está bien.
That's fine.
Okay. So you have always, there's a DUI involved, right?
Yes, sir.
You always DUI paperwork done?
No, I don't think we filled that out, Judge.
Well,
La declaración de culpable.
We'll get that done.
you have the DUI paperwork up here?
Tiene los papeles aquí para llenar.
Well, the ones they normally do for DUIs.
Lo que hacen
I don't know what
normalmente
they
para un cargo de manejar bajo efectos de alcohol.
It's AOC form.
Yeah, it's an AOC form.
María de parte de la oficina administrativa del tribunal.
I want you to do that before he leaves because,
That's fine.
Quiero que
you know,
ella
if
lo
he doesn't
haga
have,
antes de salir.
he doesn't have an
porque
interpreter, he needs an interpreter to go over that.
intérprete, él necesita
Some
un
require,
intérprete.
some don't, Judge. I
Algunos
couldn't
lo
remember
exigen,
here.
algunos no lo exigen. No me acordaba lo que usted exige a usted.
Okay,
Muy bien.
he'll need to meet with the probation parole officer
Hay que hablar con la gente de la agencia de probation and parole.
and needs to fill this DUI form out before he leaves.
Este formulario de la declaración de culpable por escrito por cargo de manejar bajo efectos de alcohol, ¿sí?
Sí.
Okay,
Thank you.
gracias.
Now, will you stay around, Madam Interpreter, to help him with that form? Right.
Yeah, grand jury sworn in,
Bring your ranger around. Hello, how are you today? Would you raise your right hand? You solemnly swear or affirm that you will perform the duties of a member of the grand jury of the Monroe Circuit Court. You fairly consider all matters brought to you, that you will keep all matters confidential, and that you will protect and defend the Constitution of the Commonwealth of Kentucky, United States of America. You do that?
Yes.
Go with Miss Gordon Anderson. She'll tell you where to go. Garrett Rush. Are you Garrett Rush? Good morning, Mr. Rush. This is 24 CR 0068 and 24 CR 0091. Mr. Garrett, were you born in 1982?
Yes, sir, I sure was.
Last four digits, social security number 5050.
Yes, sir, sure
We're
was.
here on the pretrial diversion revocation and a pretrial conference. What does the Commonwealth have to say? You know, come around this.
Plea in lieu of revocation, which is a felony plea.
Okay. Which one of the cases?
Plea will be in 24 CR 91. Revocation is 24 CR 68.
So they never pleaded both of them? And
Well,
both-
the plea's already been entered in 24 CR 68. This will just be a plea in 24.
So you're revoking the other one?
Well, I was going to, upon approval of the court, have a new 3-year sentence probated, supervised on the condition, and of course, he's got his time served already, and he would have to go to long-term treatment.
Well, I'm just for the
In
purpose,
lieu of revocation.
in lieu of revocation.
On other things.
Okay. The motion has been tendered, says you wish to enter guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person we just identified
Yes,
in
sir.
these two cases? Which would be 24 CR 0068 and 24 CR 00091. Is your judgment impaired today in any way? Have you discussed these matters with your attorney?
I have,
Are you satisfied with her advice?
yes,
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I accept the plea of guilty, I need to know that you fully understand those rights, okay?
sir.
You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt you guilty of charge. You understand by entering a guilty plea that you give up those rights. You understand that?
Yes, sir.
Let me consider the Commonwealth's recommendation, but I may apply any range of sentence provided. Well, I don't have to accept any recommendation. Prior to accepting any recommendation, I will wait a pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea. You go to jury trial. What, come around, Mr. Stockton, and give the recommendation.
Your Honor, Mr. Rush will plead in 24 CR 91 to possession of a controlled substance, first degree. He'll receive a 3-year sentence probated for 5 years. That 3-year sentence shall run consecutive with Monroe indictment 24 CR 68. Also, upon a plea of guilty to DUI first offense, he'll receive a $200 fine and cost. He'll enter and complete a long-term rehab facility through DPA, probation and parole shall transport at the morning of the bed date. He'll receive credit for time served. After he's released, he'll maintain gainful employment. He won't be released until he's final sentenced on this case, Your Honor.
Is that what you agreed to?
Yes, sir.
And you understand on the DUI, that's enhanceable if you get another, and also the felony plea, it's enhanceable if you get another felony. Do you understand that? Are you pleading guilty because you are guilty? Okay. Knowing your constitutional rights, you want to waive and allow the court to enter judgment and fix punishment within the range permitted by law. You understand, is that your signature there on the documents?
Yep.
I accept the plea and order a pre-sentence investigation report and by probation parole schedule the trial the sentencing for January 16th. Now, the fellow, Hispanic fellow that was just up here, is he still here somewhere doing that form?
Yeah, I saw Mr. Bell come up to get a form.
Okay, we're finished with this one. The court costs are what? Wait a second. $655. You can pay, hey, sir, payment $60 a month. First payment, 30 days from today, $60 a month. Well, if you're in rehab, I'll let you do it 30 days after you get out of rehab, okay? Okay, I because of all the confusion, I don't think I read that gentleman the enhancement on his DUI. He had a DUI also. So, Mr. Bailiff, you make sure we get, before they leave with him, I can bring him back and do the enhancement.
Just wiggle your arm.
It was just a little difficult. It kind of slid through the cracks, so. Evelyn Shirley.
Your Honor, Lee Davis for Ms. Shirley. I do not believe she was brought over, Your Honor. She was listed in Barron on Zoom and VineLink, but apparently she's been transported to somewhere else. I don't know exactly where. Your Honor, but she's on for a shock. We've already made our plea before you last month or so. And all the merits that we've already said. You said you wanted a place to live. and we've submitted a place that she has to live, so
Where is that?
it's in the file.
I know, what's the place that she's
It
gonna
is
live?
a sober living house in Bowling Green, Your Honor.
What do you think about this?
Well, this is the case, if you recall.
Oh, I remember all about
You
this.
remember all about this.
Go ahead and tell me what you want,
I guess I'm more interested in where Miss Shirley's gonna live after,
where she's not gonna live.
before she's not gonna live, because I remember our conversation when I was was arguing about the bond, that the court told me that I hadn't proven that that was a drug house here in the city limits of Tompkinsville, but I think I have at this point in time, upon this guilty plea and the hearing we had in Mr. Miller. So, I know Miss Shirley's,
Well, if you hadn't, I don't know what you could do to prove it was.
I agree with the court, so I'm really not in favor of it. I mean, she sold 300 pills to a gentleman in Bowling Green. I agree with Mr. Davis. The appearances look terrible because Miss Shirley's black and this gentleman from Bowling Green's white, and she's played that card. But to me, it didn't matter what skin color anybody had in that house that was selling drugs. My intent was to shut that house down and send them to prison. And that was my position, and it remains my position.
Well, Your Honor, Jeffrey Miller did instigate this case. His trafficking charge was amended down from trafficking to possession. He spent 2 days in jail by my calculations. Ms. Shirley spent over 10 months in jail, and she was given 10 years. She's old. She's 65. She's got a place in
That
Bowling
seems
Green.
relatively young to me. I don't know.
Well, Your Honor, she's
Well,
got a place in Bowling Green to transition for her to
Is
find.
she gonna come
permanent-
back to this
She
house?
is not going to come back to Tompkinsville.
I'm
Your
gonna
Honor.
probate her and
She gonna agree voluntarily to stay out in the room.
I'm gonna.
Yes, she
but
will,
The
Your
condition of the bond is that she never, during the time of her probationary period, that she not be in that house down there or in Monroe County.
Yes, sir. Thank you, Your Honor.
Okay. You what? Yeah, we'll need an order done.
Yes, sir. I will submit one.
I'm doing that because she served so much time. If she-
I understand.
You know, if she got in 5 years, she'd probably been eligible.
But
Yes, sir.
I
Thank
just
you,
didn't
Your
want to
Honor.
minimize the fact of what the activity.
Well, there's no doubt about what the activity was and what she did, and she doesn't need to be, as they say in Monroe County, gomming around here.
Yes, sir. Yes, sir. Thank you, Your Honor.
Okay. Abigail Vibert. Commonwealth versus Abigail Vibert, 23 CR 0052. Are you Abigail Vibert?
Yes, Your Honor.
Okay. You born in 1996?
Yes, Your Honor.
Last four digits of social security, 1327.
Yes,
You're here for sentencing today. Have you had an opportunity to look at pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes.
On a plea of guilty to promoting a minor in a sexual performance, she shall receive a sentence of 10 years to serve. Upon a plea of guilty to sexual abuse, 4 counts and distributing a minor matter portraying a sexual performance matter, she shall receive 5 years on each to run concurrently for a total of 5 years. The two sentences are to run concurrently for a total of 10 years. Now, explain to me what happened here.
Miss Vibert had either a significant other or a male acquaintance that she was sending child abuse sexual material to of her daughter that I don't want to describe here in court.
And Judge, the court recalls this was a resolution reached through mediation.
That's fine. I just want to know what was going on.
Come approach if you want to know exactly what the pictures.
Well, I can get the picture of what the picture is. Where is the child now?
Social service, like the house. Miss Vibert doesn't have custody. Thanks to the young child.
And she'll go on a register?
Lifetime.
Okay. I don't know. I'm going to accept this plea agreement. It's just something terribly, terribly wrong when any adult does this to another child, but to do it to your own flesh and blood is incomprehensible. to me, and you'll have an opportunity to receive treatment while you're incarcerated. And I believe that you'll have to successfully complete that before you'll be eligible to be probated at all. I don't know what to say to you, but I can't imagine any greater betrayal than you've done. Okay, she's in the custody of the jailer. John Botts.
With Sarah Botts, you know, that is a case I re-noticed. It's a notice, the motion to forfeit. I'll put it in order if that's all right.
That's fine. Sarah Botts, same thing. Larry Buttram. Arraignment says there's an active warrant out for Larry Buttram.
Well, that's put him in CIC.
Kelsey Cox, active warrant for Kelsey Cox.
She's actually in custody in Tennessee. We got a hold her on. We're just waiting for big transfer.
Okay. Tiffany Ethridge.
Your Honor, Lee Davis for Miss Etheridge. She's approaching.
Commonwealth versus Tiffany Ethridge, 24 CR 0085. Are you Tiffany Ethridge?
Yes, sir.
Good morning. Were you born in 1981?
Yes.
Last four digits of your social security number are what?
5124.
Okay. You're here on 24 CR 0085 pretrial conference and the motion of revoke bond. What does the Commonwealth have to say?
The motion to revoke bond concerns an agreement that Ms. Etheridge had with the Commonwealth. Evidently, while she was in jail on this underlying charge, she couldn't make bond. And I can call Officer Hammer on this. Evidently, there was communication to Officer Hammer that she could purchase methamphetamine and fentanyl off a certain individual. And we made arrangements through the Commonwealth to lower her bond so she could get out. And basically, over the last 3 months, she hadn't done anything. So that's the motion to revoke bond if the court, an alternative. And I guess we need to get a trial date on this case.
What's the underlying charge she
It's
has?
theft of a controlled substance. A lady was allegedly leaving the drugstore and she snatched the purse and stole it.
I remember that now.
Your Honor, we've talked with the Commonwealth. I think we've seen the light.
It's too late now. That's, I mean,
Well,
it's out and open now.
she's set for pretrial conference, I believe, next month as well, Your Honor. We
On
were,
this charge?
yes. So I believe that if we could just give her another 30 days.
But we're not gonna give her another 30 days to do anything. We're gonna set a trial date.
Yes, sir.
If she wants to enter a plea today, she can. If she doesn't, we'll set a trial date. If you want to step back and talk to her.
Your Honor, we can set a trial date if you'd
Okay.
like, sir. Okay.
Now, I'm gonna tell you about the person that stole my dog.
Yes, sir.
The person that steal your dog is gonna lie to you about whether they bring it back or not, promise to bring it back. In this situation, this lady made an agreement, received a benefit, didn't perform. So I want her to know that it's going to trial. The Commonwealth has withdrawn its offer. There won't be another offer. Okay.
Well, Your Honor, we were with the understanding that we had till January 16th. I've just learned about this. January 16th is when her pretrial conference was set. Okay,
That's correct.
now
It
I haven't
was.
been able to work with Miss Etheridge every day. We just learned about this bond revocation a week ago or so.
Well, was that when it was set?
It was said, and I filed a motion to revoke bond because she wasn't making.
Well, I understand, but the other thing is said, well, we'll be back here on the 16th then.
Yes, sir.
Okay, we'll be back on the 16th.
Thank you.
I am revoking the bond. She's in custody of jailer.
Okay.
Okay. Thank you.
Joby Grace. Commonwealth versus Joby Grace, 24 CR 0061. Are you Joby Grace? Good morning, Mr. Grace. Good morning. You were born in 1972.
Yes, sir.
Last four digits, social security number 6969.
Sir.
You're here for the purpose of sentencing. Have you had a opportunity to look at the pre-sentence investigation report done by probation pro. Is it substantially correct?
Sure.
Counselor, is there any reason this gentleman should not be sentenced?
No, sir.
On a plea of guilty to theft by lawful taking or disposition over 10,000, he shall receive a sentence of 10 years. On a guilty of burglary third degree, he shall receive 5 years. On a plea of facilitation of criminal syndicate engaging in organized crime, receive 5 years. The 2 5-year sentences shall run concurrently for 5 years. The 5-year sentence shall run consecutively to the 10 years for a total of 15 years, probated for 5 years supervised. Now, is this probation going to last until the restitution is made or?
Yes, Your Honor.
Yes, sir, it is.
Okay. Yeah, I see it down there. Okay. Restitution in the amount of $45,000 jointly and severally with co-defendants Joby Murphy, Michaela Pedigo, and Damian Hurt. $250 a month. What does the court cost this? Okay.
210.
210, you'll pay additional $30 a month. First payment due 30 days from today.
Yes, sir.
You need to meet with the probation parole officer, okay?
Thank you, Your Honor. May we be excused,
Yeah,
sir?
have a great day. Happy holidays. to you.
Merry Christmas.
Yeah. Dixie Harter. Dixie Harter, worn out.
There he is, Your Honor. She's an NCIC. And I also have another issue on this case. There was a lady named Angela Brown from Allen County that went to the clerk's office and posted, this case is a serious case. It involves Miss Harter was allegedly transporting about 80 grams of methamphetamine. And so she went to Allen, this lady from Allen County named Angela Brown came and signed a surety bond for her, provided the clerk's office an address, told them the collateral that would stand good for this. And we have sent certified mail to her about a notice to revoke her bond. And she is not at that address. It come back unserved, the bonds person. I contacted a detective in Allen County that I'm working on with a special prosecution case, and he said she kind of floats back and forth. So I don't know if the appropriate measure at this point is to issue a warrant for the person that signed the bond or do a summons or something to get her before the court.
Do they say that she made a false representation of whether she was?
Well, evidently she's made a false representation
Was
about her
it
address.
it was a clerk approved
Surety.
surety.
Yeah, 25,000. And she wrote on the bond, she's put up a RV, and Jan, I can't read what the other part is, but it's something about $10,000. I don't know if it's a car, a truck, a X97, 450, whatever that is. So,
Well, I don't know who I can issue an arrest warrant for.
but in the bond, it says, I undertake that I will appear in amenable, this is Dixie Harter, signs this. In accordance with by entering into this bond obligation, I submit to the jurisdiction of the courts of Kentucky in which any forfeiture proceeding arising out of my bail obligation may be pending, and do further irrevocably appoint the clerk as my agent with any process affecting my liability on the bond may be served, and search clerk to forthwith mail copies to me at the address below. And so,
Okay, well, what I'm gonna do is revoke the bond
Okay.
or the forfeiture.
okay,
Okay, if you'll do a forfeiture order on it,
okay.
and then that'll be out there floating around,
And I'll locate her and serve her with that
over
order.
that forfeiture order, and then I would have a,
And I guess I'll need to research how I'm gonna enforce that.
well, I'll tell you how we're gonna enforce it. You have her summons to be here on January the 16th. If she
Okay.
has not properly submitted herself to order the court forfeiting these items.
I understand.
She should be here for a show cause,
Okay.
okay, with counsel, I would put on there.
Okay.
Damian Hurt. I guess we've got an incarceration at Roder here. It was probably also, let's go to Roder. Roder, it's time to call your case. 6 minutes late, I apologize.
No problems, Your Honor. Please understand that we're having a problem here. My camera is not turning on. This is his CTO. I'm going to turn it over to Mr. Gross.
Okay, that'll be fine. Commonwealth, Kentucky versus Keith Gross. Mr. Gross, can you hear me?
Yes, sir.
You're born in 1979.
Yes, sir.
Last 4 digits, social security number 6977.
Yes, sir.
Your attorney is here today. We're here on a pretrial conference on 19 CR 0053, a pretrial conference and show cause hearing on 18 CR 00160, and a pretrial conference and show cause hearing on 12 CR 0061. What does the Commonwealth have to say?
The pretrial conference, I've spoken with Ms. McCauley. If we could have January 3rd negotiation and January the 16th, I've tendered an offer and I just need to get a response.
January 3rd, sir, at 9 a.m. Your attorney will be in contact with you. They'll have a negotiation date. Your next court date is January 16th at 9 a.m. Should you make a bond, both of those are conditions of your bond, okay?
And Mr. Gross, I have a Securus meeting with you at 1:40 on Monday. Make sure
Yes,
they let.
ma'am. Okay, thank you.
Thank you. Roder, you may be excused. Thank you for your cooperation.
Thank you, Your Honor. You have a good day.
Judge, if you'll note for the record that I'm entering my parents today for him.
Okay, that'll be fine.
Thanks, Judge.
Yeah. Damian Hurt. What do you have?
Martis.
Let us wait a second. Commonwealth of Kentucky versus Damian Hurt, 24 CR 0066. You're here for sentencing. And your year of birth, 1979.
Yes.
Last four digits, social security number 2714.
Yes.
Okay, you're here for sentencing. I need the pre-sentence investigation report here. Step and see before Megan went. Just don't go through her stuff. Just step on. She might have some secret stuff in there.
Yeah.
That's
Mr. Gross.
Mr. Hurt, Damian Hurt. Hey, Rick was wanting to go through your stuff there, but I stopped him. Commonwealth versus Damian. Have you had an opportunity to look at this pre-sentence investigation report?
Yes.
Is it substantially correct?
Yes.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Upon a plea of guilty to complicity of theft and lawful taking of disposition over 10,000, he received 10 years. Upon a plea of guilty to complicity to burglary third degree, he shall receive a sentence of 5 years. On a plea of guilty to facilitation of criminal syndicate, he received 5 years. Upon a plea of guilty to receiving stolen property, 10 years. The 2 5-year sentences shall run concurrently for 5 years. The 2 10-year sentences shall run concurrently for 10 years. The 5 and 10-year sentences shall run consecutively for 15 years, probated for 5 years. Defendant shall participate, shall pay restitution $45,000, and this shall stay in place until restitution is paid. Now, you had an issue. What kind of bond assignment do you have here? Just tell me what it is.
Judges for 5,000 of the bond. It was
Is
posted by
that-
Chris Jackson.
Is that your desire to have that signed?
Yes.
Okay. Mr. Bailiff, you recover it there for me? Whose money was that?
Chris Jackson.
Who is Chris Jackson?
It's his employer.
Okay, it's fine. You need to meet with him.
Court costs, but then that always brings up an issue with bonds. They're not allowed to release the bond until the court costs.
What are the court costs in this case?
185.
You pay that today, you get the money out.
He can do that.
You can pay it out at $5,000 too. And pay ATM and charge you more than that. Okay, Diego Morales. Commonwealth versus Diego Morales, 24 CR 0038. Come on up, Mr. Morales. Are you Diego Morales?
Yes, sir.
Yeah. You born in 1996?
Yes, sir.
Okay, I want you to test Mr. Morales here. Okay, take Mr. Morales, go with him. Jamie Piery. Commonwealth versus Jamie Piery. 20 CR 0021. Are you Jamie Piery?
Yes, Your Honor.
Were you born in 1987?
Yes, Your Honor.
Last four digits, social security number 9146.
Yes, Your Honor.
Okay. You're here for a shock probation revocation. What does the Commonwealth have to say?
Your Honor, this is a case where Mr. Piercy was shot back in April or
You
May.
need to come around so pick up on the microphone.
This is a case where Mr. Piercy was shocked back in April or May. He hadn't completed the Allen County Drug Court, and he made representations to the court if we shocked him out, he could pay his child support. He had a job lined up and he would pay it regularly and pay the full amount. Well, since then, he also had a felony pending at that time, which he subsequently pled guilty to. When we got the violation report in, we filed a motion to revoke based on the felony, which is improper because he shouldn't be revoked on that. But the problem he's got is we've amended our motion. We've set it for next month. He's not paying his child support like he's supposed to. He'll pay sporadically $50 or $150 a month, every other month. And it's about a $300 some a month obligation. So I've filed an amended motion to revoke his probation and set it for January.
I am paying most of it.
I'm making statements. Your Honor, we are asking to have the hearing take place in January. I have not had the opportunity to discuss
Well,
these
that's what you
violations with
wanted.
That's
Mr.
what I want. I'd really
Let
like
me,
to
let
pay
me
his
tell you
child
something.
support.
Yeah.
Let me tell you something. Pay the child support.
I
You know, you don't need to bore everybody to death.
I understand.
But it's your obligation. You were the one that procreated.
I understand.
Okay, and if you don't pay that child support, have it paid, on that day, we come back and bring your toothbrush with you. You understand what I'm saying?
Understand.
Okay. Thank you. Commonwealth versus Pruitt. Is it Jacob? How you say this name here? Mr. Stockton, what you got here?
That is a foot motion, I guess, filed with that lady on Zoom. I don't know.
Motion for early release filed by David Steele, attorney. Somebody look at the file there.
It is David still. It's the, I don't know if he's on Zoom or gonna appear or what.
Is there anybody here in this case? Ma'am, Candy Browning, are you a probation parole officer or what's your camera doing on here, Miss Browning?
Drug court for Barron and Metcalfe County
Drug
under
court?
Chris. Yes, sir, for the Chris Sutton case.
Have we not called it?
I haven't called. I'll get to it in just a minute. Okay, turn your camera off till then, okay?
Yes, sir.
Commonwealth versus Pruitt. It's a motion for early release. Nobody appeared here. We just pass over it. Gerald Ryan. Gerald Ryan. We already did this. What was the show cause for? Is she still here? Okay, you're Gerald Ryan. Okay, you were born in 1957. Last four cases, last four numbers of your social security are 8554. This is 24 CR 0065, pretrial conference and a motion for release. I don't know.
Yes, Your Honor. We have filed a motion. I need to get for minor child medical records from Cumberland Family Medical Center and from orthodontics. And there's an order been submitted. I'm asking the court to enter that so we can get those records. And that's pertinent as to the allegations of abuse.
Okay, stay here for a second. Do we have this set for trial?
We do not.
You want to do a conference?
Got it on January the 3rd.
January 3rd at 9 a.m. Sir, you'll be here January 3rd at 9 a.m. for negotiations, and your next court date is January 16th. And of course, you'll provide those records that you get
I
to.
anticipate asking for a trial date on the 16th if this case is not resolved.
Okay, that'd be fine. Jonathan Scott. Jonathan Scott.
I think that files.
Commonwealth versus Jonathan Scott. 24 CR 0064. Are you Jonathan Scott?
Yes, sir.
Good morning. Were you born in 1974?
Yes, sir.
Last four digits, social security number 0956.
Yes, sir.
We're here for a pretrial conference
Yes, sir.
and a motion to revoke bond. What does the Commonwealth have to say?
Well, I have tendered an offer to Mr. Scott. If he doesn't want to take that on the pretrial conference, I'm asking for a trial date. And then in the interim, I'm also, he rejects that. I've got a motion to revoke bond.
Yeah, well, go ahead and tell me about that.
Mr. Scott was in Bowling Green. He was arrested for shoplifting. He was over there in a Walmart. And he was in the knife part of the section, and he had a bunch of the knives. He took out the package and they were recovered from his person. It was at Walmart. And it's kind of odd because the case, the underlying case from Walmart that we're going to ask for a trial on is he allegedly told 3 grams of meth down in Walmart here in conference.
You've got to make a decision out here. You want to take it over?
I've got that's the mile in the Walmart. It's in Bowling Green.
Judge, may we have a moment to discuss this case? I believe he is deciding to take the offer.
Okay, we'll just step away there.
Yes, thank you, Your Honor.
Alexis Smith. Alexis Smith. 24 CR 0097. Are you Alexis Smith? Were you born in 1990?
Yes.
Last four digits, social security number 0346.
Yep.
You're here today for the purpose of arraignment. I say arraignment. Information. This is here on information. I don't have a copy of the notice, the information.
Sure, I have it included in here.
Did you retrieve that for me? Where's the original on that?
Should have been filed clerk's office.
Well, I know that.
What do we file? Original copy.
This looks like an original here.
That is the original.
We found out the public offender had cabbaged.
Is that what it was? Okay. That's been happening a lot there lately.
Yeah.
Not Miss Hill, but another party.
This remained unnamed, yeah. You're appearing here on an information that says that on or about the second day of November 2024 in Monroe County, The above named defendant committed the offense of possession of controlled substance, first degree drug unspecified against the peace and dignity of the Commonwealth. You've signed that. Is that your signature on that?
Yes.
Agree to submit it under information. We'll go ahead and place this in the record. Okay, is there been a diversion in this case, Mr. Stockton? Okay, a motion has been said that after you have been acknowledged receipt of the information and signed it, that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Yes.
Is this plea freely and voluntarily given? Are you the same person that is named in 24 CR 0097?
Yes.
Have you discussed this matter with your attorney and you're satisfied with her advice? Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
You have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel to jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, and the right to appeal this matter to higher court, require the Commonwealth to prove it on a reasonable doubt. I'm going to have to take a break here because I'm a little, got some bad drinks. I'll be right back. Go off the record.
trying to line out some treatment for Mr. Turner, and we should be able to.
Say that again, you got echoed out.
We are close to an agreement on this. We're trying to line up some treatment for Mr. Turner, and once that's done, and we enter a plea. We can pass it till January, I think.
You want a negotiation day too?
Yes,
Or
sir.
January 3rd at 9 a.m., Mr. Turner, for negotiation, and then on January 16th at 9 a.m. for your next court appearance, both of them conditions your bond, okay?
Okay.
Okay, now we passed one up. Someone was gonna go out, Mr. Jonathan Scott, I guess. Is he back in here yet?
He is not gone.
Are you talking to him or? Yeah, okay. Andrew Rhods,
Yes, sir.
come around. You have counsel with you?
No, sir, this is my directing attorney, but I'm gonna speak.
Good morning, Aaron.
You have what?
Well, I think we met one time before. I stood in for Mr. Rhodes on Mr. Groves' case.
What's the story, Mr. Rhodes? You were scheduled to be here last week or last month.
Yes, sir. So I didn't know of the date is really the answer. And so to any degree that that's been frustrating to the court, I am apologetic.
You've withdrawn from the case now.
I think you ordered that to happen, Judge,
Yeah.
so I'm no longer involved in it. That's
Yeah.
right.
I
Regarding
think
the
the
reason.
individual said that he hadn't been talked to. Is that correct?
No, sir, I had spoken to him about the offer from the Commonwealth, and I had indicated to them that I was going to redocket his cases because they weren't docketed at all. Once he knew what he wanted to do, when I spoke to him, we weren't quite there yet, and so the cases weren't redocketed. They were redocketed by the Commonwealth. That happened, and I was made known of that after the fact. I made known of that actually the morning that the court date happened. I got a text from my boss saying they're looking for you in Monroe County. The
It's always a
reason.
pleasant communication. They're looking for you in Monroe County.
No, sir, it wasn't pleasant. The reason for that, Judge, is as I said, there wasn't any court dates set for Mr. Gross's three other cases. I think we were all cognizant of that. My grandmother unfortunately died. I have her obituary here if you'd like to see it.
Well, that's not the sort of thing people usually lie about. So my condolences on the loss of your.
Thank you, I appreciate that. Her funeral was on the 7th of November. So I traveled on Wednesday, the 6th to Ringgold, Georgia. So it's about a 5-hour drive.
Yeah.
I had her funeral on the 7th. I traveled back on the 8th, but I
Okay,
did not
well,
work on those.
I'm gonna say that this is just human error and you're released. Having to travel down here today is punitive enough.
Thank you, sir. I
I
appreciate
think
that
so.
very
You're
much.
released and it will, I will show on your record that appropriate explanation as your absence was offered to the court and accepted. Okay?
Yes, sir. Thank you very
Okay,
much.
thank y'all very much.
Thank you.
Yeah. Okay, we've got Jonathan Scott still out there negotiating. Well, that's fine, that's fine, yeah. Let's go to Barron County Detention. Barron County Detention. Yeah, where is he? Bring him on up here.
There you go. All right, see.
Hand that up here, Jim.
Yes, sir, Judge.
Now, we're back on 24 CR 0031.
24 CR 0031.
Jose, previously, you pled guilty to a DUI.
De manejar bajo fotos del alcohol.
And
Yes.
I failed to inform you that if you get another DUI or subsequent DUIs, that this can be used against you for a harsher penalty because you have this DUI. You understand that?
Va a tener que ir penas aumentadas debido al hecho de que hoy se ha declarado culpable ante el cargo de manejar bajo fotos de alcohol. ¿Entiendes? Yes, yes.
Okay. And we also said if you get another, was he a pretrial diversion or felony?
Pretrial version.
And if we do the pretrial diversion and we revoke it and you get sentenced as a felon, that can be used against you also. Do you understand that?
Alternativa, entonces, los demás cargos serían desde penal, ¿lo entiendes?
Sí.
Yes.
That seems to satisfy, he's gonna be on his way. Did he meet with probation and parole officer? Okay, thank you very much.
Thank you.
Thank you.
Okay,
Your Honor, may the interpreter be excused?
well, I mean, I know it's been a joyous morning. If you stay around a little longer, you can have lunch here. They got great barbecue in town. Thank you very much. Merry Christmas to you.
How much?
Yeah. Barron County Detention Center. Are you on there? Okay, let's call David Buck up. David Buck.
They're muted, Judge.
Commonwealth versus David Buck.
They're muted, Judge.
Huh?
They're muted.
Yeah, somebody needs to turn your microphone on there. The Barron County Detention Center, have somebody to turn that little red
It's
button.
on.
Is it on now?
Okay, am I muted also?
No.
Okay. Y'all hear me all right?
Yeah.
Commonwealth versus David Buck, 24 CR 0017. We're here on the pretrial diversion revocation. Buck, were you born in 1982?
Yes, Your Honor.
Social Security number 2125.
Yes.
Okay, what's the Commonwealth say? Mr. Stockton, you come around to the podium, please.
On Mr. Buck, in 24 CR 17, the Commonwealth has filed a motion to revoke his pretrial diversion because when the probation parole did a home visit, he had firearms in his residence, including long guns and one handgun. So I filed a motion to revoke that. Also, a member of the Kentucky State Police is presenting that case to the grand jury today for new charges. So I guess,
Well, I think the prudent thing to do would be scheduling for a negotiation day.
yes.
There's gonna be probably a firearms charge, Mr. Buck. I don't want you to comment on it right now, but your attorney, I'm gonna give you an opportunity to give some sort of explanation, so I won't revoke you today. So,
Okay, Your Honor.
back here on January the 6th for a negotiation day and January 16th for your next court date. And that way you can wrap it all up together if there's some kind of problem.
Your Honor, I guess if Mr. Bell's not going to represent him on 24 CR 17, he'll need appointed counsel.
Mr. Bell. You don't represent this gentleman here?
I did on the original charge, but not on the revocation. I would have, but he's got the new charge, so I think they're gonna have to go together. I would think they would. I mean, if it was me, I'd want them to go together. You want me to do it, Jared?
Do you have one of those bond assignment forms? They seem to take precedent over other things here.
You want me to do it, I'll do it. I don't feel
Like the bench had been rushed like it was on that, over there in Adair County, Russell County. I didn't know. Well, I'll give you an opportunity to talk to him.
All right.
Mr. Buck, Mr. Bell's gonna come over and talk to you about this additional charge. And if you can't reach an agreement, I want Mr. Buck to fill out a form as far as his eligibility for a public advocate on the thing. And let's do that in time for them to meet with him on January the 3rd. Okay? Here's someone's January 3rd is a negotiation date.
Okay, yes, fine.
Next court date is January because we want to give Mr. Buck an opportunity to roll this stuff in together. Okay, thank y'all very much. Mr. Bell will be over to talk to you, Mr. Buck.
Thank you, Your Honor.
Commonwealth versus Brockman Carter. CR 0090 and 24 CR 0. Are you Brockman Carter?
Yes, sir.
Last
Yes,
one.
sir.
Social Security number 0829. We're here on a pretrial conference on both those. What do you have, Mr. Bell?
Judge, we don't have an agreement. We do have a trial date set for the 13th. I did talk to Mr. Stockton again this morning. We've negotiated this case a long time and pretty in detail. There was some changes that he made today that I think may resolve the case. The only issue I've got is I'm leaving town Tuesday and won't be back until first of the year.
Well, basically, Greg, the only issue I know of is the original paperwork had 180 days in it. They get Mr. Carter out of jail around the 1st of March. And I've told Mr. Bell that if he wants to be released after sentencing and when he's oriented into drug court, I would agree to that. But if that's the only issue, I don't know why we can't enter the plea today. I can send the modified paperwork over there. If that's what Mr. Carter wants to do. If not, we'll just leave it on for trial.
What about Mr. Bill?
Did you understand that, Brock?
Yeah, most of it, Mr. Bell.
What do you say?
He said most of it. He understood most of it.
Basically, what he's saying is what do you want to do, Judge?
Go ahead.
What he's saying is instead of getting out in March, you'd probably get out sometime in January, middle of January.
Sure, yes, sir. Yep, Mr. Bell, yep.
Does that interest you?
Yep, yes, sir.
I got a problem with the microphone there. It's breaking up.
Okay.
Mr. Brockman, can you stand back away from that microphone a little bit and see if we can understand you?
Yes, sir.
What I want you to do, Mr. Bell, is go out and see if you can contact Mr. Carter by phone so you can have a discussion with him on this. I don't think it's right to put him in a situation where you're making a decision where we don't know whether it's been communicated. So
Your Honor, Mr. Bell. Mr. Bell.
They're going to come out and talk to you on the phone so you can talk to him better, okay? And
Yes, sir.
then I'll bring you back up, okay?
Is there a specified number
Is there a number that y'all want him to call over so we can get him on the phone?
He can just call the jail number and I'll let them know I'll take him out. It's 270
651
651 8806.
Mr. Bell knows it by heart.
Yes, sir. Thank you.
Yeah. Chandler Moon. Well versus Chandler Moon, 24 CR 0013. Are you Chandler Moon?
I am.
You born in 1999?
Yes.
Last four digits, social security number 4979.
Yes.
Is that correct?
That's correct.
You have an attorney?
I do not.
Yeah, I'm gonna ask public advocacy to stand in. You have an interview with Mr. Moon pre-trial? What I'm talking about for you is whether you has the right to have an attorney or
No,
not.
I'm sorry, Your
Judge,
Honor.
I believe he was DPA District Court.
The DPA represents you in district court, Mr. Moon? Did the public defender interview you and did they represent you in district court?
I do think so, yes.
Okay, wait just a second here. Wait just a second. I can't understand what they're saying. Can you understand what they're? What I want to do, if they try to get the Zoom back in, you think it might help anything or what? The jail personnel, have y'all had any complaints about garbled sound?
No, we haven't.
Turn your sound down.
I'm gonna turn ours down and see if that helps you.
No.
Right here.
Stand back away from.
Talk to him, Chandler, see if it works.
Can you hear me now?
Can y'all understand what he's saying now, Mr. Stockton? Mr. Stockton. Now, state your name again, Mr. Moon.
It's Chandler Moon.
There's a distortion somewhere.
Yeah, I never have seen that before over there.
We'll
We'll go ahead and do this arraignment, and then we're gonna have to try to work some on technicalities here. Mr. Moon, you have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with selling or receiving a vehicle with a bad vent, possession of a radio capable of receiving police radio, receiving stolen property, and trafficking in stolen vehicle for stolen parts. You understand what those charges are?
Yes.
Counselor, do you, recognize, Mr. Moon and acknowledge his identity, receive the indictment, wait formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Here we'll set a, negotiation day on January the 3rd and the next court appearance on January 16th, and I'll sign a reciprocal discovery order. And what's Mr. Moon's bond here?
That calls that he's got charges outstanding in West Virginia and in other states. So
Okay, well, we'll just have to have a bond here if we do anything about the bond, okay? Your attorney will be over to talk to you. Okay, Commonwealth versus Pedigo. Michaela Pedigo, are you Michaela Pedigo?
Yes, sir.
Were you born in 19?
Yes, sir.
Last four, so number 0940.
Yes, sir.
34 CR 0059 for a pretrial diversion revocation. Xanda Myers, attorney record.
she was in, at the plea.
Judge, this is DPA conflict. Ms. Myers was serving as DPA for the purposes of the underlying case.
Y'all can handle it now.
We can handle it now, yes,
Okay.
the
We
conflict
have
is
a
resolved.
diversion revocation. What does the Commonwealth have to say?
Your Honor, this Miss Pedigo was involved in this criminal syndicate. She took a 15-year sentence and she was supposed to pay restitution. She was interviewed by Mr. Collins. She admitted to IV drug use, methamphetamine. Probation parole wanted to send her to long-term treatment. And I don't know if she refused or basically said she could do it herself. I might want to clarify that. So that's the reason we filed this motions, because she basically refused
If
treatment.
you raise your right hand, let him be in the middle. The testimony you're about to give is the truth, the whole truth, and nothing but the truth.
It is.
Come up, Senator, state your name with whom you're employed.
Chase Collins, I'm employed with Department of Corrections, Probation and Parole.
Go ahead, Mr.
Judge, this is the first call. I have not spoke to Ms. Pedigo, and I'm not ready for a
Well, you
hearing or
didn't tell me
anything.
that. I can't read your mind.
Well, Judge, I wasn't real sure what was going on for a second. It's been a morning.
Well, I mean, this train's moving.
Yes, it was. If we can get a date in January to give me the opportunity to speak with Ms. Pedigo.
Can you
And
put a pin on her?
Pretrial diversion, we won't be able to.
Judge, I don't know what it is that you asked Officer Collins.
Whether the state's gonna pay for or the citizens of Monroe County.
Okay.
That's a personal identification number. PIN. Because she is in the PEN. What we'll do is continue a month and we'll have a negotiation day. Try to get you in drug court. It might help you to take these days, but what is it that you say the violation is, Stan?
She was committed to using probation wanted to send her to long-term treatment. Because that's a red flag, they need treatment. So she didn't have so that's the reason I filed. So I think the red court might pick it up. Because they can send her to long-term treatment, or let her work, do what she wants to. Depending on how she does.
Well, Ms. Pedigo, the discussion here is to try to do something that might keep you they claim that you admitted to an IV. And I don't want you to say anything one way or the other, that meth by IV, that's pretty dangerous activity. They're afraid that until they get you into, they're gonna try to get you into drug court. I think it would be to your benefit to wait. We'll have a negotiation day on January the 3rd and the next court date on the 16th. Is it possible for me to go ahead and do a referral to drug court before then?
Yes, because then a plea entered on the diversion, we can do a referral.
Okay, I'm gonna go ahead and do a drug court referral, and your attorney can tell you what would be implied by getting into drug court. If we do a referral, they could vote on you that date, couldn't they? Probably on the 16th, they could vote on you that date, and get an orientation set up. You follow what I'm saying? If you agree to
Yes,
go,
sir.
might get you out a lot sooner, maybe 2 months, okay?
Okay. Thank
Okay,
you.
thank you very much, man. Billy Rich. Commonwealth versus Billy Rich, 24 CR 0096. Are you Billy Rich?
Yes, sir.
We're here for the purpose of arraignment. Information. Make a copy of it real quick. Mr. Rich, were you born in 1983?
Yes, sir.
Last 4 digits social security number 5027.
Yes,
You're
sir.
You're here for an arraignment, but by virtue of information that you signed and agreed to. Is this your signature on the docket? Can you see that?
Yes, sir.
Okay. What does the Commonwealth have to say?
This is the docket plea, Your Honor. It's
Okay,
a-
you acknowledge Mr. Rich's identity, receipt of the information, waive formal reading. It's already been read. So you already have a copy of it, right?
Yes, Your Honor.
Okay, you want another one?
I have one.
Okay. Okay, what do you have, Mr.
It's
Stock?
a felony plea, Your Honor.
Okay. Motion been tendered, sir, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol.
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in this indictment?
Yes, sir.
Judgment impaired in any way today?
No, sir.
Is your judgment impaired? You know what's going on here? There's a problem.
Yeah.
Okay. Are you satisfied? You had 3 times to discuss his advice. Have you reviewed the evidence Commonwealth has against you and you believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to have you do not have to enter a plea today. You understand that?
Yes, sir.
Certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm gonna go over them and then ask you at the end if you understand them, okay? You have the right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, the right to be represented by counsel in your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove you guilty beyond a reasonable doubt of the charges against you. Understand by entering a guilty plea today, you give up those rights. You understand that?
Yes,
And I
sir.
make the Commonwealth's recommendation, but I may apply any range of sense provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait for this investigation report to be done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation?
Mr. Rich will plead guilty to possession of a controlled substance, first degree, first offense, receive a sentence of 2 years, probated for 4 years. He'll enter and complete the Monroe County Specialty Program. He'll receive credit for time served. He'll obtain and maintain gainful employment once he's released. All evidence be destroyed, and he'd be released once he's been sentenced in Oregon.
Now, have I signed a drug court referral on this? Okay, I'll sign a drug court referral so they can vote you in on January the 16th. And we'll sign. Do what?
I didn't say anything, Your Honor.
Are you shaking your head no?
Oh, no.
No, you weren't shaking your head no?
No, I was shaking my head no, Your Honor, that I was not saying anything at that moment.
That's perfectly clear. Okay. Now I may consider the Commonwealth's recommendation. I may apply any range of sense provided law. I don't have to accept the recommendation. Once I look at the pre-sentence investigation report, if I decide to impose a harsher sentence, you have the right to withdraw your plea of guilty. Now, I've already gone over that once. We've heard what the recommendation is. Is that your understanding of the recommendation, sir?
Yes, sir.
Now, are you pleading guilty because you did commit the act charged in the information?
Yes, sir.
Knowing your constitutional rights, have explained it to you, is it still your desire to give up those rights and enter plea of guilty to charges and allow the court to fix your punishment? Is that correct?
Yes, sir.
In future, guilty pleas or convictions on felonies could be enhanced under the persistent felony offender law. Do you understand that?
Sir.
Could you hand me that document up here? I'm gonna let you see. You see that? Is that your signature on there, sir?
Yes, sir.
I'll accept the plea. Sign the referral to the drug court. They'll take a look at it and they'll be presented probably that same day. And then as soon as the orientation is ready, you'll be ready to go, okay?
Can
Court cost of the case or what?
165.
165, I'll allow you to pay that.
what about my bond, sir? Can I get a bond?
Do what?
Can I get out until they do the assessment?
No, you'll get out as soon as you get oriented. So the assessment they'll do the assessment and then they'll vote you in
On the 16th.
on the 16th. And then shortly thereafter, we'll set up an orientation. You get out then, okay?
Okay. Thank you.
Very much. Timothy Shirley.
No, Mr. Brown submitted an order continuing that check. It's been continued.
Mr. Shirley, your attorney presented a motion to continue this. Is that correct?
January, yes.
For what purpose?
Well, I want to include one other case, but we should have. an
Hey,
agreement.
your attorney, Mr. Brown, will be over to see you soon. They're on negotiation on another matter with you. And they'll take this out. You want a negotiation day too?
Yes, on the 3rd.
Negotiation day on January the 3rd and the next court appearance on January the 16th. Thank you, Mr. Shirley. Aaron Southworth. 24 CR 0067 and 24 CR 0040. Commonwealth versus Aaron Southworth. Are you Aaron Southworth?
Yes, sir.
Born in 1984.
No, sir.
What year were you born?
92.
What is it?
1992.
1992?
82.
92. Last four digits, Social Security 9112.
No, sir.
What are the last four digits, Social Security number?
7202.
7202. Hey, you're here on a motion for shock probation on these two cases. What do y'all have to say?
Your Honor, we did file a motion on this.
Speak up a little bit.
Yes, Your Honor, we filed a motion for shock probation for Mr. Southworth. Since the time of that filing, however, we had reached an agreement with the Commonwealth and there was an agreed order submitted just yesterday. So we would ask if the court would take a look at that and grant that motion.
Yes, this involved theft of some guns from the state. The co-defendant pled and cooperated and is paying restitution. And I had my staff speak with the victims and they're in agreement. They would like to see Mr. Southworth go to long-term treatment, pay on the restitution.
So on an agreed order, we'll grant shock probation. Is that correct? And send him to long-term treatment. When y'all have him a bed ready?
We have the bed letter, Your Honor, which we will submit to the Commonwealth. I just received it just a little while ago.
Once you give it to him today.
Yes, sir.
They've got your bed date letter over here. The Commonwealth's gonna do it and he approves it. I'll sign the order today. We'll get you transported as quickly as possible, okay?
Thanks, sir.
Great, thank you. Callie Strong. Commonwealth versus Callie Strong. 22 CR 0061. Are you Callie Strong?
Yes, Your Honor.
You born in 1969?
Yes.
last four digits, social security number 7609.
Yes.
We're on a pretrial diversion revocation, Mr. Stockton.
Your Honor, this was passed and he was, assessed for drug court. He was, accepted today. And so my recommendation would be to release him once the orientation date, so he can begin the special.
Okay, you were voted into drug court today, sir, and they'll set an, okay, they'll have to do an orientation will be when, Mr. Stockton, Mr. Stockton,
Yes, Your Honor.
when will be the orientation?
That's the big mystery of the morning, Your Honor. We can't find that.
They always email me in all three
Yeah.
counties when they're ready for.
Should be the next few days.
I thought it was Monday, but
So you've been voted in. As soon as we can get the orientation date, we'll let you out on that date. It should be sooner rather than later, okay?
Okay.
Okay, thank you very much. Christopher Sutton.
Yes, sir.
24 CR 007 Commonwealth of Kentucky versus Christopher Sutton. Are you Christopher Sutton?
Yes, sir.
Were you born in 1995?
Yes, was.
The last four digits, social security number 1321.
Yes.
We're on a pretrial diversion revocation, Mr. Stockton.
Yes, Your Honor, this is a case, Mr. Sutton has a theft by unlawful taking over $1,000, 5 years and 3 years on possession for a total of 8 years. My understanding is Ms. Browning's here to testify that he was in drug court in Barron County. He had a sanction, and when he went to the Barron County Jail, he had meth on his person. And the problem I've got, Ms. Browning's available, but the officer at the jail's got a stomach virus this morning. He's not available.
Who's his attorney? Mr. Bell? You're listed as attorney over here. Christopher Sutton.
We sent Ms. Hill, Mr. Bell, yeah, that he was last counsel of record.
not that I'm aware of, Judge.
Do you know Mr. Sutton?
Chris, have I represented you?
Yes, it did.
Yes, 24, July 24.
Oh, okay.
Thank you. I thought you knew these.
You got any kind of thing it's good off?
Probably not. He's already in drug court. So I don't know.
What are y'all gonna do with him in drug court over there, Ms. Browning?
We had a hearing 2 weeks ago, Your Honor, where the judge, Alexander, took testimony from myself and the cop and just put it on the record, but did not let Mr. Sutton testify because of a pending felony case he has coming down the pike. And he just put the case off for a month to review it to see if he's gonna be indicted on the new felony charge.
I can't understand.
She basically said they had a hearing in Barron County. And Judge Alexander, a month, see if there was one indicted on the, I guess, the promoting contraband, which is released in the jail.
Judge, right now, all I can tell you is I can't remember any
Let's
of that.
take, you know something about this? Probation parole here knows something about it. Come on up.
I hate to be standing here with things. I just don't remember none of them, Judge. I just feel like.
You don't have to tell us you don't remember everything. You just sit
Well, I
there.
don't lie
You just-
about it, you know?
Well, I didn't ask you about it, so you don't have to lie if I don't ask you.
Why not?
Go ahead.
Sure.
We're not gonna do anything to him today.
No.
You got your job done.
Your Honor, he was, from what I understood from Miss Browning, he was serving some sanctions for drug court for some positive drug tests. He showed up to the drug court office after being released from the jail after serving a sanction. They went to arrest him, and as the officer patted him down at the drug court office, he had methamphetamine in his pocket.
Oh. Well, let's just, are they gonna charge him, Miss Browning, you know where they're gonna charge him over there or not?
Yes, sir, he was charged with possession of methamphetamine.
Okay, so it's not a contraband case. Yeah. So they didn't find it at the jail. Yeah.
He had it in our office.
Okay, well, we'll just continue this until January 16th and see what.
Would you consider any kind of sanction on him, Judge?
I don't have him in the drug court. I'm gonna go let's see what they're gonna do over there. They hadn't told me they're gonna kick him out of drug court yet, have you?
No, we have not.
So let's just see let's give it some time, see what happens over
Thank
there.
you, Judge.
Steve Benson. Steve Benson.
May I be excused, Your Honor?
Yeah, thank you so much. I'm sorry you had to wait this long.
No problem. Thank you, Your Honor.
Steve Benson, Commonwealth versus Steve Benson, 24 CR 0095 for the purpose of arraignment. Do you have a lawyer, Mr. Benson?
No, I'm at Nick Carter's going to
District
represent.
Court, did the public advocates represent you in district court?
No, Judge, Mr. Carter did, and he's informed me that he has not been retained in the circuit court action.
Your Honor, I have him on a separate F case currently in.
Okay, I'll appoint public advocacy. All right, it's good enough. All right, okay. You have a right to remain silent, Mr. Vincent. The grand jury of Monroe County has returned an indictment charging you possession of a controlled substance, methamphetamine, possession of drug paraphernalia, and expired plates. And failure to transfer a registered vehicle. You understand what those charges are? Is that correct?
Yes, Your Honor.
You acknowledge Mr. Vincent's identity, received indictment, waive formal reading and arraignment, enter plea not guilty, observing all pretrial motions.
Yes, Your Honor.
Set a negotiation day upon January 3rd, the next court date on January 16th.
Thank you,
Okay.
Your Honor.
And is there someone else? Is that finishes?
No, what's that?
Morales.
Well, who do we have left?
We got Diego Morales, who you wanted drug tested, who's not been able to produce a sample. We got Jonathan Chad Scott. I need to know if he's taking his felony plea or if we need to have a motion to revoke bond.
No, wait.
He's gonna do a plea, I understand. So we did his felony.
Okay. Is that everybody we have in jail?
No.
Now we have Mr. Carter.
Okay, I got Mr. Carter, so if everybody hold on there. Oh, they're just gonna have to wait a minute.
throw everything at you, but I
They're
just
just
thought I'd
gonna
throw
wait
it
for a
in.
minute. You know, thank you for telling me though. All
Really, Bill needs to ask him to read on Mr. Sutton's case and he needs to be appointed live.
And Judge, I represented him and anyway, we just ended up with a situation that
Which case is that?
Mr. Sutton, I couldn't recall, his
Well,
case.
point public advocacy.
Thank you, Judge.
Y'all get that one?
Yes, Your
Mr.
Honor.
Sutton.
Okay, now where are we? We're on Jonathan Scott. Where we at here, guys? Help me out here.
Diego Morales.
Well, they got Jonathan Scott here too. Well, come bring him around. Commonwealth Kentucky versus Jonathan Scott, 24 CR 0064. Are you Jonathan Scott? Are you Jonathan Scott?
Yes, sir.
Okay, were you born in 1974?
Yes, yes.
Last four digits, social security number is 0956.
Yes, sir.
You're here on 24 CR 0064 on a pretrial conference. I understand you wish to enter a plea. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 24 CR 0064? Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yeah.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to require the Commonwealth to prove on a reasonable doubt that you're guilty charge against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that? Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting any recommendation, I will wait the pre-sentence investigation report. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Mr. Stockton, will you step over behind here and tell us what the Commonwealth's recommendation is?
Your Honor, Mr. Scott will plead guilty to possession of controlled substance first degree. He will receive a sentence of 1.5 years to serve. He'll receive credit for time served. Commonwealth opposes probation or shock probation. All evidence in this case will be destroyed.
Is that what you agreed to?
Sir.
Are you pleading guilty because you didn't commit the act charged in the indictment as amended? You doing so your own free will? Know your constitutional rights to explain to you, it's still your desire to give up these rights and enter a guilty plea on the charges and allow the court to fix your punishment in the range permitted by law. Is that correct?
Yes, sir.
Okay. You understand after entering this plea, any future convictions of felonies could be enhanced under the penalties of persistent felony offender law. You understand that? Do y'all have the document? Can you retrieve that, Mr. Bailiff? Where's the plea agreement? Is that your signature on there, sir?
Judge, it's Mr. Scott.
Oh, yeah, this guy's walking. Is that your plea? Is that your signature on there? I'm sorry. Oh, look, somebody moved. I accept the agreement or pre-sentence investigation board schedule hearing on January 16th.
Thank you.
Okay, he's in custody of jailer. Now, what do we have left now? Diego Morales. Where is he? Is that the last one? Is this the last one? Brockman Carter. Commonwealth versus Diego Morales. What do we have? Okay, you're in the custody of the jailer. You're going to the Barron County Jail.
I can't judge.
Would you give him one more chance to try, Judge?
Well, I'll give him a chance.
They asked me to give a drink of water and then after that, he told me to
Go see if you can produce the sample and we'll handle your case. Other than that, you're going to Barron County Jail and I'll see you on the 16th of January.
Yep.
Okay, let's go back to Brockman Carter then. What we got there now?
Show cause.
Well, this is the last case. Okay, Brockman Carter. What we got here with Brockman Carter?
It might be a few minutes because we sent the paperwork over there.
Do what?
He's still saying that.
I don't know, because they've been taken out to look at his paperwork.
Mr. Carter, if they let you look at the new paperwork, Mr. Carter, if they take you.
Not yet, Your Honor.
Your Honor, I'm in here, I don't have access to that. It'll be just a second. And I'll have to go and get it.
Okay, well, let's just, I guess
We
we can,
still have,
I'll stay here as long as it's necessary. We'll send the paperwork over there. You want to take the rest of the prisoners? I guess is there anybody else you have we hadn't talked to there?
I just have the show cause docket. I have 7 per show cause.
We always just continue those if they're incarcerated, so that it's not really necessary.
It was.
No, let's continue the show cause if they're incarcerated.
Okay, y'all are all, the 7 of you that are incarcerated, we'll continue those and just set them up.
There's the one, Jan.
Wait just a second.
That we added on. Yeah, if they'd been in there, if you couldn't pay the $100, you might want to take.
Who is that? Wait just a second.
James Pollard, he's the one that's been here for 94 days.
Thanks, Paul.
He's been there for how many days?
95 now.
For $100?
Yeah.
Okay, well, I'm gonna release him.
Thank you, Judge.
Yeah, I'm gonna release him today. Now, is that the last one except Mr. Carter?
It is, and
Okay, well, let me, can I have all your guys' attention here? For years, the first 12 or 14, well, I guess the first 10 years that I was on the bench, every Christmas, I spent Christmas Day in the jails in Adair and Russell and Clinton County, taking packages and letting people know that I had not forgotten them on that day. Now, because of COVID regulations and things like that, I can't do that any longer very much, but I want you to know that I have not forgotten you. It's very unfortunate that you're in the situation that you're in, but this is the time of year where hope springs eternal. And I hope each and every one of you have a better year this coming year. I hope that you can communicate with your families. I don't worry as much about you as I do your families being without you on this time. It's hard on them. Each one of you know that. So I want to wish each one of you a Merry Christmas and sincerely hope that next year is a better year for all of you. Okay, thank you very much. If you can take all those folks back. We'll wait for Mr. Brockman Carter. Okay, thank you.
thank you.
Okay, what do we have left here? Okay, bring the grand jury. This water is just running out of my nose. It's clear. What is it? Huh? Thank you. I mean, it's running out. Let's go off the record, please. All rise for the grand jury, please. Okay, everyone can be seated. Well, I want to thank each and every one of you. I've been told by the bailiff that y'all have all volunteered to serve another 6 months on the grand jury. Is that correct? They lied to you. So you've been dealing with people that aren't completely truthful for 6 months. It's just a reoccurrence of that. Is that correct? Okay. Mr. Foreperson, you have the report ready?
I do.
Okay, you sit the bailiff there. Did 9 or more of you agree on each one of these things? Okay. Okay, ladies and gentlemen, I have executed the document. If these folks are incarcerated, we'll probably have a summons issued to keep them where they are. If they're not, we'll issue warrants. We'll take a look at their criminal background to see if they're a danger of a flight danger or danger to the public. We'll set a bond sufficient to take care of that. So I'll turn that in now. We're seating a new jury today at 2 o'clock. Is that correct? But they don't officially take over till next month,
January 1st.
January 1st. So in all probability, you won't be called back in case of, unless there's a case of riot or insurrection. Things are looking less likely all the time that we're going to be having any riots and insurrections, but you still could be called back for a special grand jury. And after that, when will they get their checks?
Probably be the January 1st, December. I mean, EDC referred to me.
They're not gonna get their checks by Christmas? Well, I mean, so don't go overspend. This $12.50 a day you get. So don't make any commitments on it, okay? So thank you very much. Your participation is crucial. If any of you hadn't been on the grand jury before, I'm sure it was an eye-opening experience. I hope you don't have traumatic syndrome of any kind from it, okay? Well, we appreciate what you've done, and this court system could not run without a grand jury. It's a very important job that you've just done, and the people of Monroe County are appreciative to you. You are excused unless you're called back. All rise for the grand jury. Well, you go back on the record. Should have go back on the record. Yeah, I know. I've just been here 14 years. That was because my nose is red. Okay, let's go here. Yeah. Now, what do we have? Carter?
Diego Morales and
Di-
show cause.
Show cause docket. Where Diego Morales still back there working on something?
He's trying to test.
Oh, yeah, he's trying to pee. Go to the show cause docket. Truman Adams. Truman Adams. Now, what's this $1,235 for? When's the last time Mr. Adams made any payments?
I just got out, Your Honor, I just got out the 21st of November. Out of jail, 21st November. I haven't made no payment yet.
You pay $100 before January the 16th and $100 every 30 days after that, okay?
All right.
Thank you. Truman Adams. That was just another one on you. That's another one you had, just pay the $100. You had two things. What we got here?
Your Honor, he was positive for methamphetamine.
Yeah. Well, you're in the custody of the jailer then. We'll set a negotiation day up on January 3rd and the next court date on January 16th. Dalton Birdwell.
He's incarcerated.
Dalton Birdwell is incarcerated. We'll pass. Wait. Where's he going?
Give my wallet.
Pass over Birdwell. David Buck. They're both in jail. Incarcerated, pass over David Buck. You better go, you need to go back there.
That's a separate David Book, but he's also incarcerated.
David Ray Buck.
They ran that Texas.
Well, them incarcerated, pass over Christopher Burke. Christopher Burks.
Your Honor, he's been returned as a parole violator, they deferred him 12 months.
Okay. Pass over him, he's incarcerated. Kelsey Cox. Any payment?
Going to Tennessee to, get her up here.
Jail in Tennessee, pass over. Amber Crow. What? Okay. Do a show cause order, issue bench warrant, pay $160. She a Tennessee resident. Or,
So she's been supervised at the Barron County office.
Yeah, I've got her. I'll have it took care of that.
James Dockery. Still in jail. What about James Dockery? What do y'all know about, is he making payments? How much does he owe? It didn't have it on here. Issue a bench warrant where he purged himself paying 180. Connie England. Bench warrant purged paying $50. Herschel Hammer. Herschel Hammer. In custody. Yes. Hands over. Devon Howard. In custody also. He's in rehab. Pass over and reschedule. Shannon McGuire. Twenty-four CR 0045. Are you Shannon McGuire?
Yes, Your Honor.
Okay, you owe $290. When's the last time you made a payment?
Last month, I'm gonna have surgery in a couple of weeks on my knee, and then once I heal up, I'll be going back to work. I should be able to make a payment in January if that would be okay with the courts.
Okay. Pay $50 by January 16th, okay?
Thank you, Your Honor.
Hope it goes well. John Murphy. Jody Murphy, excuse me, Jody Murphy. Jody Murphy. Okay. Does that say $47,415? When's the last time you made a payment? Hasn't made a payment.
That amount would be restitution.
She probated last month.
Yeah, I mean, it hasn't even been 30 days.
What did the restitution agreement call for?
I remember having it for 40-something thousand. I'll pull it up.
We'll pull it up here, okay.
There was multiple there.
She on probation, did you say, or she incarcerated?
She's incarcerated, okay? Are y'all?
You need to talk to her, tell her she needs to make the restitution payments.
I spoke with her Monday, Your Honor, and stressed making those payments. Transferred her probation to Barron County. I think they accepted her there today, so I can call her off.
Have her be back here on January 16th. Charles Muse. Anybody know about Charles Muse?
He just got him on probation, and I seen him last Wednesday. And we talked about him making his payments, and he acted like he did, so.
He made a payment? Okay, issue a bench warrant for Charles Muse. He can purge himself by paying $200. He still owes $545 but $200.
All these people that owe up to 47,000, they didn't enter their plea until November 14th, and they had 30 days to make.
Okay, that's the reason I'm putting them off till,
So it's not even been.
that's why I'm putting them off to the 16th, right? That'd be 30 if they had made any payments. With that amount of money, we need to make sure they get in line and start making their payments. So that's 2 days over.
No.
When
It's
did they enter
not up.
plea?
It's not 30 days yet, is what I'm saying.
When did they enter the plea?
November the 14th.
I know, but I'm saying.
Well, yeah, it's 2 days, yeah.
Yeah, January 16th will have been over 30 days. Right?
Yes, their 30 days is not up today, so
I
I'm not
know,
sure why
that's-
they're on for show cause.
Shouldn't have
Yeah.
been. That's the reason I'm putting them off on to January 16th. Yeah. Michaela Pedigo, she's another one of those individuals that, right? Yeah,
He's in custody.
she's in custody anyway. James Pollard,
That's the one that was in jail when you released him.
yeah, he couldn't pay $100, right? Had him back up here on January 16th. If he hadn't made at least $100 payment by then. Austin Pruitt. Anything on Austin Pruitt? Issue a bench warrant for Austin Pruitt and purge himself paying $243. Garrett Rush.
Easy card.
Passover, Alicia Russell.
Rehab.
Passover. Eric Taylor. Do they know anything about Eric Taylor? Issue a bench warrant, he can purge himself by paying
He's in the Allen County.
Passover Eric Taylor then. Ansel Williams, he's in rehab. Dakota Williams, rehab. Justin Wisdom. You Justin Wisdom, you owe $115. What can you do about that?
I just got a relation prison like a week ago.
Okay, I tell you what, how about January, pay it before January 16th, okay? Yeah, just pay, if you pay it before, then you don't have to come back up here, okay?
Okay, thank you.
Yeah, Merry Christmas to you. Okay, that concludes the show cause docket. And we got Brockman Carter, correct? Does Mr. Garrett representing, who represents Mr. Beth?
He stepped out, talked with Jesse. They're out the door.
About this case? Let's go off the record till Mr. They come back. Thomas J told me he's glad that you started working again. She's getting soft. He's hot now. We're not giving that other $10 to their county jail. I mean, he's hot. We went to fiscal court meeting the other night, and the county judge said, "Well, we're trying to negotiate. I'll tell the public, we're trying to negotiate a new deal with the Adair County Jail." He says, "We're not only broadcasting for our training."
He was talking about before he's trying to negotiate.
Sharp.
I don't know. Are we going?
I couldn't do anything with it.
There's out.
Give me that Brockman Carter file.
Did you watch it? Watch them every time. He probably went to you, David. They won't let me in on smart enough.
I got it right here. Commonwealth versus Brockman Carter.
Yes, sir.
Let's see here. It's 24 CR 0090 and 24 CR 0080. Mr. Carter, were you born in 1983?
Yes, sir.
Last four digits, social security number 0829.
Yes, sir.
Have y'all reached an agreement on this case, Madam Commonwealth Attorney? What do y'all have here?
Yes, Your Honor, we do. We have a felony plea.
Okay, a motion's been tendered, Mr. Carter, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 24 CR 0090, 24 CR 0030?
As far as I know, yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
You review the evidence the Commonwealth has against you, believe you're fully informed about your case. You understand
Yes.
that you understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to a higher court. If you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty. You understand that by
I do, yes, sir.
entering a plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed below. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report to be done by probation parole. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Upon a plea of guilty to wanton endangerment first degree, 2 counts, the defendant shall receive a sentence of 5 years on each count to run consecutively for a total of 10 years. Upon a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 5 years. The 10-year sentence and the 5-year sentence shall run consecutively for a total of 15 years. He will serve 180 days in jail beginning. What was that?
It just needs to say that he will be released.
It will say down here, it says in here, he'll remain in jail until the morning of Monroe Specialty Court. Okay. He will serve 180 days in jail beginning from September the 10th, 2024, with the balance probated for 5 years supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances first offense, the defendant shall pay a $200 fine with cost. The defendant shall have a mental health evaluation and follow any and all recommendations. The defendant shall obtain public employment. This excludes any type of self-employment. The defendant shall forfeit the Glock 26 Gen 4 9mm with serial number BCY B504 to the Commonwealth and the holding agency to be disposed of in accordance with the laws of the Commonwealth and the holding agency. The defendant agrees to forfeit 69 counterfeit $100 bills with serial number PM25782 1811 and indictment number 24 CR 00090 to the Kentucky State Police, Post 15, to be disposed of in accordance with the laws of the Commonwealth and the policy and procedures of the Kentucky State Police, Post 15. The defendant shall enter and complete the Monroe Specialty Court. He shall remain in jail until the morning of Monroe Specialty Court orientation. The defendant shall receive credit for time served. However, he shall receive no credit for time served on home incarceration. The defendant shall have no contact with the victim or his real property. The defendant shall obtain gainful employment or do minimum of 30 hours per week of gainful employment until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Mr. Carter, is that your understanding of the agreement?
Yes, sir.
Okay, you're pleading guilty because you did commit the acts charged as amended, not in the original, but as amended.
Yes, sir.
Okay. Are you doing so of your own free will?
Yes, sir.
Okay, knowing your constitutional rights, have explained it to us, you desire to allow the court to set your punishment. You understand that by entering a plea of guilty, any future convictions could be enhanced on the felonies or the DUI, on both of them, they could be enhanced. You understand that?
I do, yes, sir.
Okay, is that your signature on the docket there?
Yes, sir.
Yeah, I'll accept the agreement, order pre-sentence investigation report and schedule the sentencing for January 16th. And you got the DUI paperwork?
No, Judge.
Well, you need to have it done in here on the 16th.
All right. Judge, I just want to say on the record, we do have a clear understanding that he's to be released as soon as he enters into drug court.
Yes, as soon as he gets the orientation done and that day, when he starts the drug court, we'll release it.
Thank you, Judge.
Okay, well, thank y'all. Is it Barron County? We have anybody else?
No, sir.
Okay. Well, thank y'all. Merry Christmas, to y'all.
Good to see you.
You under the weather a little bit?
Drainage, it's coming. I don't know where it's coming from. Okay, let's go off the record. It's just rolling out. That's just like squirting out. But she says my eyes are bloodshot.
They are a little bit. Yeah.
Okay, now, are we off the broadcast over here too now?
16th, please.
Graves versus Graves.
Judge, that's just our motion to intervene to allow us to provide services.
Okay, that'd be great. Graves versus Graves.
January the 16th. No, that was,
Yeah, no, there's two.
yeah, okay.
Turner versus Guffey.
Judge, that's our review, and Mr. Guffey is here. What was he ordered?
Mr. Guffey, you want to come around?
He doesn't pay this out,
Okay.
but he brought this because he got to work. So. I don't know. I haven't. 17 days.
Judge, Mr. Guffey had started making payments and he hadn't made this month's, but then he's brought discharge instructions where he's off work for the next 2 weeks. So we probably just need to review this, the January 16th date. And he needs
You want to give him a target at what he needs to do by then?
he needs to catch up. This is the only month that he's missed since he started paying, which is just 2 or 3 months, but he needs to pay December, he needs to be.
How much a month is that?
Yeah. How much is his payment? $1,052 a month. He needs to make 2 payments.
Okay,
He's back to him. They keep him. Take a shot.
January 16th.
Yeah.
Hammer versus Hammer.
January the 16th, please, Your Honor.
Heston versus Heston.
January the 16th, please.
Taylor versus Houchins.
January the 16th, please.
Hudson versus Hudson.
January the 16th, please.
Jimenez versus Jimenez.
January the 16th, please.
I know you're proud of me after all these years.
When you get the first name, that's when we'll really brag on it.
Yeah. Joyner versus Joyner.
January the 16th, please.
Dye versus Jones.
Is this just
Support. Support. This is
Sean Jones here?
not like either of those here.
She could swear in Miss Staples, please, Your Honor.
Swear the testimony you're about to give is the truth, the whole truth, and nothing but.
Yes.
State your name for the record, please.
Taylor Staples.
And you were approached by Kendra Jones to begin child support case against Sean Jones, is that correct?
Marshall Dye.
Marshall Dye, I'm sorry. Is that
Yes.
correct?
Yes.
And he is before the court given notice of this hearing?
Yes.
And you've calculated child support to be $568.89 per month? Is that
Yes.
correct? That's based upon the income of both parties and the Kentucky child support guidelines.
Yes.
And that will go into effect on what day?
November.
For retroactive to November when we filed the motion.
Has Mr. Dye been in, to speak to you guys? He
Yes.
provided
Emailed me his
information. So he's
latest.
aware it's coming,
Yes.
right? Okay. Jones versus Jones.
It's continued.
January the 16th, please.
Presswell versus Keener.
Ms. Staples, you are under oath. You're familiar with the case of 24 CI 94. Ashley Creswell versus Kevin Keener, is that correct?
Yes.
Mr. Keener has an arrearage as of today of $14,526.81. Is that correct?
Yes.
As far as you're aware, he's an able-bodied person capable of providing this support. He's neither incarcerated nor a member of the armed forces. Is this correct?
Correct.
And this was transferred from another state is how the arrearage got so big before we got involved. Judge, we'd ask you, holding in contempt, make a lump sum payment of $2,000.
Has he been in? Did y'all have him come in?
We mailed him the motions.
And does he live here or does she know? How did it get?
She lives here.
Where does he live?
Or no, he lives here. She does not live
I
here.
was gonna say, you know,
Yeah, no.
They
Sorry.
transferred it here because he lives in Monroe County, in Kentucky. It came from,
Well, if it is an arrears from another state, no criminal action would lie here then, right? So the only thing you do is civil, right? Okay.
okay.
So in order. Keith versus Keith.
January the 16th, please.
Page versus Page.
January the 16th, please.
Pennington.
January the 16th, please.
Rich.
January the 16th, please.
Brown versus Scott.
January the 16th, please.
And what is Scott's first name?
Maine.
What?
Maine.
Okay.
I call him Q-Main, but he says Quamain.
Wilson versus Shelton.
January the 16th. Please.
White versus White.
January the 16th.
That concludes your docket.
That is all.
Thank y'all very much. Okay, Hollingsworth versus Asher. Okay.
Judge, I filed a couple of motions. One I'd like to take up first is a motion limiting. I represent the defendant, Tina Asher. She is the executrix of the estate. And back when this case was first filed, I served interrogatories on the plaintiffs, asking them to state the names of expert witnesses they intended to call and to provide the typical Rule 26 information. They did file a disclosure saying that they intended to call the medical people who were in the medical records, the physicians and so forth, that had been disclosed in the medical records, and that their opinions would be limited to the information that was in those records. Well, we've taken a lot of those doctors' depositions. None of them have testified that they are in a position to testify that Mr. Hollingsworth, at the time he signed the will, was not mentally competent. So we filed a motion to have this case set for trial. The plaintiffs, in fact, filed another pretrial disclosure of expert witnesses saying that, you know, we're just going to call the people that are in the medical records and so forth. Well, lo and behold, I get I guess it was December 6th. And remember, they're the plaintiffs here. I get an expert disclosure from the plaintiffs, and they've retained Dr. George Thomas, who is an ER physician in Bowling Green, retired now, and say they want to call him as an expert witness to provide testimony as a consulting expert. Judge, this is too late. This trial is set for January 6th. We're all ready. We've deposed doctors right and left. We even deposed some yesterday. And I'm fine with to the extent that those have been deposed and so forth. But for the plaintiff to wait till a few days before we have the pretrial conference and all of a sudden spring a new consulting expert on us when we don't have time to take the deposition, we don't have time to go out and retain an expert to refute Dr. Thomas's testimony. We think that given the fact that this case has been set and it's too late, they ought to be restricted to who they have disclosed as of the pretrial conference, that their opinions are limited to those that are contained in the medical records, which is exactly what they had told us from the get-go is what we're going to do in this case. And that Dr. Thomas should not be allowed to testify.
But what do you think Dr. Thomas is going to testify about if he doesn't look at the medical records that exist?
Well, he can look at the medical records, he can review the deposition, but understand he never saw the plaintiff. He's just coming in at the last moment.
Well, that happens all the time, doesn't it? It was people who are
I
expert
understand,
witnesses
Judge, but
don't
he's
say.
never been disclosed. They just have sprung this on us at the last minute. Anybody can read the medical records, anybody can do that, but and the doctors that have all testified have all said, we don't know, we can't testify to a reasonable degree of medical certainty that Mr. Hollingsworth did not know the object of his bounty or the nature of his state at the time. We cannot testify to that. And to all of a sudden.
Don't doctors always testify to that usually when they weren't there? They could have been a lucid interval or something, you know?
It could have been. But to try to spring on us an expert witness.
What is this? How long have you had this doctor?
For about a week. And
what's the deal waiting this late?
Because we didn't have all the records nor all the medical proof. And Your Honor, I don't want to mislead the court, and I want to make sure Mr. English isn't misleading the court. Dr. Thomas also has not been disclosed to say that within any reasonable degree of medical probability, Mr. Hollingsworth was X on this day he signed the will. Okay, so that's not what he's offered for. His disclosure that I have filed, and I got that consultant.
What is he going to be offered?
He's basically going to offer his opinions. What they do is this, Mr. Hollingsworth was seen by a myriad of physicians in the week around the will. And what he has done is he's looked at those records and he has certain opinions regarding what was leading to the confusion and the altered mental state that's reflected in those records. He has not been offered, as is kind of suggested by Mr. English, to come in and say, like, that Mr. Hollingsworth could not have written a will on any certain date. No doctor could do that unless they happen to see them that day, which would be a rarity in these types of cases.
Well, I lost one to your boss like that. Well, I'd seen him that day and I lost it anyway.
Well, we never know what happens in that jury room.
Yeah.
I think we can all agree on that. The other thing I want to add here is the motion that was filed didn't address Dr. Thomas. The motion that was filed originally by Mr. English said you shouldn't even allow the jury to hear from the treating physicians.
No, sir.
But excuse me. That's what his motion said. He said the disclosure was not adequate. So in my response, I cited to the court the written decision, the published decision in Ripito versus Fees, in which a disclosure of treating physicians far less specific than mine was found to be proper. So what's happened is, I think, counsel for defendants got my response that actually had some authority with it and talk about pulling a switch. They've decided now, well, we can't get the treating physicians thrown out. Let's try to get Dr. Thomas thrown out because for some reason it's insufficient or late. Your Honor, he hasn't addressed the fact that your local rules provide for expert witness disclosures 2 weeks before trial. That's in local rule 2 sub 5, I believe. And so the reason I filed my disclosure when I did is as soon as I got his opinion, I disclosed it. He could not formulate that opinion until all the records and all the medical proof from the actual treating physicians were received. And frankly, Your Honor, if he did otherwise, that'd be the first question Mr. English would ask him on cross-examination. Did you not formulate a premature opinion without all the facts blah, blah, blah. So this suggests we can't take a discovery deposition between now and trial next month. Number one, no one's asked. We're a week after I disclosed him.
But I think the problem is not whether you can take a deposition in that time, it's just what they find in the deposition, whether they would have time to refute that by getting their own experts to take issue. I mean, that's the larger problem. I'm sure y'all can find 30 minutes, 2 hours, 3 hours, whatever, to take that deposition, but it seems to me to be a little unfair for you to bring someone at this date to be deposed and for them not to get their experts to have a look at what that person has said so they can refute it. But of course, you could bring them live, obviously.
But understand, well, number one, the reason I filed my motion in limine before I got his expert disclosure, because I was afraid something like this was going to happen. I mean, to wait until the very last minute to spring something like this. We don't have time to if doctor says, well, I think from reviewing the records and all this, I think he may have been confused and may have said, the treating physicians have talked about that. We took a deposition yesterday that they talked about what medical conditions Mr. Hollingsworth suffered from.
And what would this additional expert, if the treating physicians have testified that he had all of these things wrong with him that might have cost him?
I might just get that disclosure, Your Honor.
Yeah.
And I do want the court to understand one more thing. Mr. English is referring to one disclosure. I have filed two in this case. I filed one in September, identifying all those people that I was aware of at that time.
Mm-hmm.
So, you know, you can't disclose until you know, and you can't know until you've got all the underlying facts.
What did you not know about this former emergency room? He never saw a patient.
Yep.
So
What I did not know, we still in September did not have all the records. And when we were here in September, we actually, we extended the discovery period so as to obtain that medical proof that in part, I'd had some of it.
are you going to call anybody live, or are we all going to be on the screen with your witnesses?
My witness, well, I will have Ms. Howard.
I'm talking about expert witness.
I will not have any, that I know of, I will not have any experts live. I'll just read portions of the depositions that have been taken.
You're going to read depositions, you're going to show them on the screen.
Well, show them, maybe edit those portions so that we don't have to go through everything.
I'd like to know what he intends to show by written, because we've taken video depositions actually for trial of all the treating
Well, see,
physicians.
the problem you get to is where people start. The reason I ask you that is we start editing, and then you get to the issue of the other side's got a right usually to see something in its entirety so you can get into context.
Understand.
You know.
And to the extent if is an objection or something like that, we'll
At some juncture, and I would say it'd be pretty soon, y'all need to share with each other what you're planning on playing, what portions of any depositions that you plan on playing.
and that's fine. If he's the one who's taken most of these depositions. I've cross-examined the physicians. And if he'll let me know what he intends to play, I'll let him know in sufficient time and so forth.
I could tell Mr. English that right now. The videos I intend to play, the testimony by video, first of all, they have to be medical doctors under the rule.
Right.
Okay, so he knows that. Number two, every one of them, I've taken a discovery deposition and then a specific trial testimony deposition. He already knows that. Back to Dr. Thomas, the gravamen of his opinion. The only one that really matters here, frankly, is the fifth opinion that's cited in the disclosure in his report, where he lists 7 contributing factors of Mr. Hollingsworth's physical condition that attribute to his altered mental state. Okay, and what that is that's upon review of the entire chart, not just the oncologist portion, not just the emergency room portion, not just the nursing notes or the primary care or the cardiologist. It is a conglomeration of all those records. And frankly, if there's a trouble getting an opinion contrary to that, the only trouble would be, I don't think any medical doctor would disagree with that opinion. because it's not even
I'm
necessary.
sure you can find one somewhere.
Well, maybe, for the right price, possible.
And I'm sure he's paid Dr. Thomas the right price to come in and.
Well, I don't know Dr. Thomas because he might be sitting in the emergency room with Burkeville. That's what usually people retire. They might come to McCain Hospital today, so I don't.
I could probably produce a dozen cases where Mr. English's partners have utilized, but Dr. Thomas, if Buzz would like to see.
Well,
that.
but that, you know, that's.
Well, maybe he knows Dr. Thomas better than you do.
Fine.
Okay, here's the thing about it. I mean, this is lingered on. If I allow this testimony in, how much more time would you like to have if you want to push the trial out? I mean, I don't have to push trial. I got dates. The reason I have dates is I don't set trials unless they're ready to go. Okay? I mean, they got to have ready to go. And we're scheduled on this one for when?
January 6th.
I thought it was 8.
I believe it's January 6th.
Well, we want both of you gentlemen to be here the same day. Now, it helps. I don't have to have your presence, but let's see here. January what?
6th.
Yeah, I 6,
My
7, and
client's
8.
saying 6 as well.
6, 7, and 8. I have it set here.
Judge, we do have a trial going in Clinton County or in Cumberland County.
Yeah, that's right. We anticipated that y'all wouldn't take 3 days. But we can always. That's a criminal trial, right? These defendants usually don't care whether they're tried or not, but this one is incarcerated. Isn't that correct?
Those care more usually.
If they're incarcerated, yeah.
So let me see.
I believe he is. I believe he is.
Judge, the only other thing on the 27th, we have the Carter versus Monroe County case that's set for trial that will.
Is that a big one?
Well, that'll go for a long time, you know, and I'm sure you're gonna need the week before that to prepare it for sure. Yeah, the trial that was scheduled for the 13th was planned today, isn't that right?
Mr. C is not incarcerated.
He's not, okay. What about the Clinton County trial on the 15th? Still on,
They met with the victims.
gonna go. Do you think we can try this thing in 2 days?
It's 2 or 3. The medical proof actually, as it's come in by video, it has not taken too long.
Yeah.
The lengthy part of the trial will not be the capacity part, it'll be the undue influence element. And the relationship between Miss Asher and the decedent and those interactions. In my opinion, that's how I see it.
The Bayes trial will go on the 3rd and 4th, correct? Of February. Do what?
Have you an amended indictment and they said that they can't find it.
You won't be able to try it that way. Let's look at February 3rd, 4th, and 5th.
Judge, I've got that
anything about-
Monroe County case, the Carter case is the
The week before that. Okay,
So
that's
that's
correct.
just.
I got you. What about the 11th and 12th?
I've
Well, I've got a medical appointment on the
They said
10th.
it's gonna take 3 days. or we can-
I've got a trial in Warren Circuit Court, the 11th and the 12th.
Okay. The next week is a prosecutors conference, so it's usually, but we've got Warner versus Stern. What's that?
Property rights case with Mr. Little,
Who's involved in it?
Mr. Little and Mr. Garman and Mr. Ramsey. They've already filed their pre-trial compliance and jury instructions, so.
Great,
so-
great. Well, I tell you what I'm gonna do. I'm going to allow you to take a discovery deposition of their expert at their cost. You know, I think that won't cost your client any additional money. And after you take that discovery testimony, if you feel strongly that you cannot proceed and represent her interest, then we'll get together again and pick a date.
That's fair.
Okay. That's the only thing I need to do. It's gone this long, so if y'all will get together and get,
By the cost, I assume you mean my expert's cost and then also the cost of deposition itself.
that's right.
Okay.
Yeah. Okay. And then I'll be available anytime after that. Let's say 4 days after that, 3 or 4 days after that, you just get a hold of me and we'll get on Zoom and do something. It works very well. I was on 400 Royal Street in the Louisiana Appeal Court and took a plea from here in Monroe County last week on Zoom from 400 Royal Street. It's a beautiful building. So, okay. Thank y'all very much.
Judge, I had also filed a motion, just very briefly, if you recall, one of the issues when we first filed this case, we asked that the assets of the estate be liquidated so we wouldn't be fighting over, we know what the money was. They objected, but they ended up posting a bond to do that, and we filed a motion for judgment on that bond.
I have filed a response. I mean, the request is basically one of summary judgment. And I mean, it's premature until we get a decision out of this case that.
Well, the bond will still be there.
Okay.
Yeah.
The bond will still be there. And if you think that there have been things disposed of?
No, it's not well, number one, there were cameras there and there was a flash card on one of the cameras. And I'm not saying there was anything nefarious or anything else, but Mr. Wilson who's an associate with Mr. Davenport, took the flash drive off that camera and it lost it.
I've asked Jimmy about this. He says that's a mischaracterization of what happened. There was a trail camera in Mr. Hollingsworth's residence when I believe Miss Howard and Mr. Wilson was trying to inventory things. They looked for that SD card for 15 minutes before they both agreed they didn't know where it was. And so to say I'm not casting an aspersion, but it's like my 16-year-old daughter says, whatever you say before but doesn't really matter.
Yeah.
It's what you say after the but. And so I'm not even sure the motion referenced that issue, but regardless, it's premature at this point.
It is, and if at some juncture you feel strongly about it, there's a missing evidence sort of situation, I guess civil cases, you can ask for a missing evidence instruction, can't you?
Yes, sir.
Yeah, so maybe that would be the way to do that. If they feel like this or that was on there that would bear some impact, I'll address that at the time, okay?
All right.
Okay, thank you very much.
Thank you, Judge.
Y'all get together and schedule that now if you would.
I think there was a motion to compel I filed. We got a response and an affidavit. That issue's now moot. I'll file a notice of remand for that.
Okay, if y'all give me an order to circulate it, and then let's get that deposition done sooner rather than later, so I'll have some time.
I'll provide him dates this afternoon.
Okay, thank you so much. Yeah.
Thank you.
Short versus Cook.
Good afternoon, Your Honor.
Yeah, everyone that's not involved in this particular hearing, will you switch your cameras off temporarily? Mr. Poindexter can keep his on if y'all just switch your cameras off. That makes the record a little bit better. Okay, what do we have here? Motion to set trial.
Yes, sir.
Okay. Have you filed all the compliance?
This is going to be a bench trial, Your Honor. And so it's going to be a bench trial.
Yeah.
And we've done discovery. We've tried to reach an agreement. We don't think it's possible. So we think it's going to be better just for you to have a hearing on it.
Well, what issues ultimately will be tried, since I don't have instructions on the thing? What have you agreed on anything, or?
We've agreed on some things and it's not worked out very well. The trial is going to be regarding the validity of a lease versus ownership, that kind of thing.
Yeah. Okay. Do it in one day, you think?
I don't see how it would take more than a day.
Okay.
I agree.
Is all the discovery been finished in the thing?
Yes, sir.
No deposition left to do or anything?
No, sir.
Excuse me. How far out do you want this?
Mid to late January.
How about January 13th?
That'll work, Your Honor.
Okay.
Well, I'm sorry, Your Honor. I'm going to be getting back on a flight the night before around 11 p.m. Do you have another date?
Well, I guess I do. I'm going to go ahead and double schedule Megan on January. Y'all just check January 31st. That's it. That would be the 5th day that Monroe County Bridge is good.
That's fine with me, Your Honor.
That works for me, Your Honor.
Then work it that way. I'd like for both of you, without serving it on the other party, to send me kind of a trial brief as to how many witnesses you're going to have and what you expect them to testify. So if I need to do any research, since there are not any instructions left, it kind of leaves us hanging there. And so if you have any legal theory or what you think your witness will say, it would be helpful to serve it maybe a week before that. Okay.
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 Yes, sir.
Thank y'all very much.
Thank you.
Thank you, Judge.
Yeah. Okay, the next case is Liberty Federal Credit Union versus Denison.
Good afternoon, Your Honor. Lee Braun on behalf of the plaintiff.
Okay. And we've been here before on this, correct?
I don't believe
thought-
so, Your Honor.
You represent Dennison, is that right?
That's
What's your
correct, yes.
defense to this?
Your Honor, we've acknowledged in our answer that there is some amount owed. We dispute the amount. Plaintiff suggests.
Speak a little louder so they can pick up.
They're suggesting that our main argument with the amount owed is the way the vehicle was sold after it was taken back into possession, but we've never gotten an accounting of payments received, fees charged, or anything. So we don't think that a summary judgment is proper when there's nothing on the record that actually shows where this number came from.
Well, how do you,
I mean, honestly, Your Honor, if they give me an accounting and I believe that that accounting is correct, I'm going to advise my client that we need to pay. I mean, that's.
do you have an accounting counselor?
Your Honor, I would think that at the very least, we could put something together that hopefully would satisfy defendants and their counsel.
Well, you know, there's some way that you put something together to get this judgment amount you submitted. So it shouldn't be too very hard, okay, to get that together. I'm going to have a rule day in, what's the rule day next week? Is it Cumberland County next Thursday? Next Thursday in Cumberland County, I'll have a rule day. Since you're participating by Zoom, that won't be too bad for you. And you can get on, counselor, if you want to by Zoom.
Oh, at what time?
Well, at 2:00 or
1:15.
1:15 or as soon thereafter as you may be heard.
We have a new jury at 2.
Okay, 1:15. We'll work it in some way.
Okay.
And maybe y'all receive an agreed order about the amount. So maybe by close of business tomorrow, if you'll get that amount down to opposing counsel, and if you reach an accord on it, I'll go ahead and enter the judgment. We won't have to come back. If you don't reach accord on it, we'll have a short hearing next Thursday. And you need to be prepared to offer any kind of evidence that would challenge the amount on a hearing that day. So we'll go ahead and advance this thing, okay?
That sounds great, Judge. And counsel, would it be possible to get an email address that I could send that to you at?
Yes, it's Basil Law Firm at glasgow-ky.com.
Terrific. Thank you.
Okay, thank y'all. Geoscience Consultants versus James Driver. This is a motion to compel.
Yeah, Your Honor, second one, actually. I think I entitled it motion to show cause.
David Cross is not involved in this case. Usually it's on a motion. to compel.
Both my clients live in Tennessee and we sent it to them 6 weeks ago for their signature. That's where, to sign off on the interrogatories.
Well,
I hope they provided the answers, you know.
Yes. No, we had the answer. We typed it up and sent it to them for their signatures.
After consulting with him, type the answers up.
Yes.
Okay.
Yeah.
Judge, you gave until September 20th. I was being facetious. I apologize. You gave until September 23rd, the last time we were here. We are a month and a half. 6 weeks ago was your deadline.
When you think you can get this?
As I'm trying to say nicely, they're hard to deal. I can't get them.
Well, they're going to be harder to deal with when I dismiss their case for.
Well, I'm the plaintiff.
He's the plaintiff.
Please don't dismiss me.
Well, I thought I got y'all switched around.
And they should be motivated because they're having to pay a bond on this every year. Because it's a mechanics lien.
Yeah.
They had to put up a bond to sell the property.
Which the bonding company hasn't filed an answer for reasons I don't understand. And
I don't remember this case at all.
It it's going to be a bench trial and there's no reason to bore you with the facts until then.
Oh, yeah, it's the, you and I talked about that like. day
Look,
before
Tustin
yesterday.
Bluff,
Yeah.
gas station.
This is one where they paid to a previous owner and the previous owner allegedly didn't get it done, right? And.
No, they did the work. The state of
But the
Kentucky
spade is the wrong
supervisor
person.
issued it to the person who owned it. That person passed away in Tennessee. They just processed the money through that guy's estate in Tennessee.
Yeah.
But the facts are a little different than that, but again, it's immaterial to the motion. I'm entitled to my discovery. My client desperately wants to have a trial on this thing. You're not going to schedule it till I get this discovery. They're spending money having to have me come down asking for things we should have had 6 months ago.
Okay, well, I'm gonna award you $300 attorney's fee for having to come down here. I know that's not even your hourly rate, but
It's fine. Judge.
you know, I'll give you $300 for having to come down here and give them 14 days to completely comply. If not, you can bring your motion, you know, for their failure to comply. Just tell them that the judge is like already threatened to enter a judgment against the wrong party. So, you know, he's like, heck. Okay.
All right, thank you, Judge.
Thank y'all very much.
Do I need to tender a different order or is the one I
Yeah,
have sufficient?
I just tender one and just say that, you know, that they should be compelled to completely comply 13 days and they'd be awarded $300 for your trip over here.
Oh, thank you.
Okay. England versus England,
Mr. Rich Alexander contacted me and said that everything.
been pulled. Okay.
It's the third year, that's so much.
England parties, have y'all reached an agreement on this thing?
Yeah.
Okay, well, I think they're gonna submit, is he gonna be online here?
No, the email I got said his case was set for review on my motion to show cause. Everything was worked out and my client has been paid her attorney's fees as ordered by the judge. Please report to the court that this matter is resolved.
Okay, it's resolved, you can both go. Okay, thank you, yeah. Liberty Federal Credit Union versus Heathcock's motion for judgment.
Afternoon, Your Honor. Lee Braun on behalf of the plaintiff.
Yeah, okay. I'm having a little trouble finding this. What docket, what in my book here, I can't.
No, it's not, some of them are on for review, so we don't have a motion.
Well, this is a motion for default judgment here. Tell me what you got going on here.
Judge, plaintiff filed a motion for judgment on the pleadings. Mr. Haithcox Jr. did file what I guess would be called an answer, but in that answer, he didn't respond to any of plaintiff's allegations. He didn't deny signing the contract at issue, didn't deny breaching the contract at issue, and didn't deny the amount that.
I'm having trouble understanding you. It could be that you just need to talk more distinctly, rather than, because I can't hear you, okay? It might be me, but I don't think it is. We just don't have that good. You got a motion for judgment on the pleadings.
That's right.
Yeah, and did Mr. Hathcock, was he represented?
I don't believe he was, Your Honor.
Okay. You haven't been before me on this case before. I looked at this pleading, I can't. The complaint was filed on September 13th on an account, correctly?
That's correct.
He replied a file a responsive pleading on the 18th.
Yes.
He made an admission as to the complaint.
Yes, the defendant's response was about a paragraph long. It didn't respond individually to the allegations, but the defendant, He failed to deny signing the contracted issue. He failed to deny the amount owed under the contract.
Did y'all repo this vehicle?
Judge, I am not sure if this vehicle was repossessed or not.
Well, could you find out real quick there if it was? You got a file, whether it was
Yes, let me pull up this account.
You're asking for $9,055.61.
Yes, a principal amount of $9,055.61.
Plus reasonable attorney's fees, plus prejudgment interest, plus court costs, plus post-judgment interest from the date of the judgment. And what are your reasonable attorney's fees gonna be?
We're requesting $1,500 in attorney's fees.
Well, I
And
want you,
Judge,
I want you to send me a breakdown, you know, on the thing. I don't know why this gentleman is not here, but I have a problem sometimes where these cars are repoed and then sold for like $400 or something like that. You know, I just have a problem with that.
Understood, Your Honor.
So-
And I can confirm that the vehicle was resold, and I'm happy to include a.
So give me a
that.
breakdown of those things and it'll stand submitted, okay?
Thank you. Will do.
Okay. Thank you. Okay, we have McClendon versus Hall and Muse, correct?
Yes, Your Honor. This was my motion to schedule this for a hearing. We had this motion on last month. I represent the Jimmy and Ashley McClendon. They have filed this custody action against the parents of the minor child. When we filed it to be set for trial last month, the father, Charles Muse, was in jail, but he was getting out that day. Since then, he has been released. We gave him notice of today's hearing date. I actually spoke with him, or he was come by my office last week, and it was my understanding he was going to be here today, but then he didn't show up for show cause this morning, and I believe a bench warrant has been issued. So I don't know what the court wants to do now with scheduling a hearing, because
Do we know anything about this case, Megan? Okay. Give me a little factual background.
yes, so my client Ashley McClendon and her husband, they've been taking care of Miss Hall and Charles Muse's son for a very long time.
Are they related?
No
by blood?
relation, no relation.
How was the child placed
He's
there?
15.
How was
16 now.
how was the child placed there?
She took him on vacation and didn't bring him back.
I'll let you respond just a second, okay?
Yeah, my client.
Hey, chill out. You're all right. Okay.
Just over time, he just started staying with them, and it become very permanent.
Hey, do you have an
last year.
attorney?
No, they're not. Can't afford one.
Have you talked to Apple Ridge?
No, but I'm gonna contact them.
Okay. I think that this will require a hearing.
Yes.
But I don't feel really comfortable having a hearing on this without her being represented. And of course, you know, I don't know what kind of financial situation you're in. I won't talk to you about that, but it appears to me that people do other things with their money, but sometimes they don't find money for the most important things. And I know attorneys are expensive. So, how long do you think this hearing will take?
Hour or two. I don't.
What kind of papers do they have where they have some right to this child right now?
They don't have any papers, Your Honor. They're asking to be qualified as a de facto custodian and then to be given custody.
How old is the child?
He's 16.
Well, it's hard to tell a 16-year-old where they're going to live and that sort of thing. You know, it's very difficult. Y'all, until you get legal counsel, I'm not going to ask you what your optimal outcome of this thing is going to be. You know, do you get to visit the child now?
I have custody of him. The sheriff goes and gets him whenever I say.
Okay, well, I'm asking you, how much more do you want the child than you have it now?
Oh, he should be home. I went to pick him up last week from ball practice. She jumped out of the car and threw her hands up on him. So the law was called.
Well, okay, but you want the child full-time and want them, wait just a second. You want the child full-time and want them out of the child's life, is what you're saying.
My child respects them. He loves them because.
I'm just asking you what your optimal situation would be. Is that the child stay with you and then go see them when he wants to? Is that? Okay. Okay, well, we'll have a hearing on this thing. You need to get legal counsel within. This is another one. We got a jury over Burkesville next Thursday. You know, what we got after the jury over Burkesville next Thursday?
I don't know what's scheduled.
Probably too soon next week, but
And our other issue that just literally come up today was that Charles Muse, the father, he's got a bench warrant out for him. So I don't know if he's going to be.
well, we'll know where he'll be.
Yeah, well, I don't know how the court wants to deal with him if he's incarcerated and.
Well, he'll have to have a guardian ad litem.
Yes, so,
you know, but it wasn't for much. How much was he supposed to pay? You remember?
$200.
Yeah. Now you could advance him.
Okay. I guess, yeah, but we're ready.
Now you and Mr. Muse are not in a relationship now.
Absolutely not.
Okay, so there's no doubt he's the biological father.
Yes, I have sole custody of him.
Yeah, I know. I'm just asking a question. I'm not up to it.
He's not a part of his life. He never
Okay,
has.
well, he could be a part if he objected to this or that, if he shows up, but he might not show up. Who knows, you know? What would be a reasonable time for you to be able to get an attorney, do you think?
I'm gonna call first thing in the morning.
Okay.
Because I went and spoke with social services to be advised on what I needed to do.
Yeah.
And since they weren't involved, and this was just a personal matter.
Yeah.
And she told me the same thing, just to contact legal aid. Brad Apple.
Apple Red, yeah. Okay, well, if we had a child of tender years, I would be more concerned about the child being with someone that you alleged has not been that involved. But it appears to me that the child can take care of its own needs until we get this sorted out, you know, somewhat. But I will tell you that I will be ultimately influenced by how liberal you are about letting this child continue to visit them during this time period. Might not should be, but I am. Okay. It's fair. That's fair, isn't it? You know what I'm saying? So let's say in 2 weeks, you get an attorney and give the name of the attorney. And I can schedule, we won't have to wait to another rule day or whatever. We just work it in and I can have a hearing because there's specific findings that have to be made on whether someone meets with the criteria of de facto custodians. They're specific findings, they're factual findings, okay? And you'll hear that testimony. So get an attorney in about, let's say 2 weeks from today or before then and notify and Ms. Gordon Anderson, you can work with that attorney to set up a hearing after they've had an opportunity to consult with this lady, okay? Okay. And I know this is stressful and it might not turn out the way either one of you want it to be, but I guarantee you that I don't know anybody involved in this thing and I'll be as fair as I can to both of you, but primarily concerned with what's the best interest of the child. Okay. That's why we ought to focus on here. Okay. Thank y'all very much.
Thank you.
Howman versus Mary Tim Smith, Johnny Beth Hammer.
Yes, Your Honor. That was my motions and I have re-noticed in for January.
Well, good. Good. It's always good news.
Just, Scott Jennings had commented on Twitter about AOC, always disregarding everything but the butt. After Davenport's argument, I thought that was a weird coincidence. Ready, Mr. Basil? Yes, sir.
He watching YouTube.
Maryland, okay, I guess the next Philpott versus Philpott. Okay, are you Wendy, is that correct? Okay, and you are Larry? Okay, and you want me to waive cost to allow you to proceed in form of paupus? What kind of, are you disabled or what do you do?
I'm disabled.
What do you do, ma'am?
I'm disabled as well.
Okay, and y'all have a marriage that you say is irreparably broken, is that correct? How long were y'all married?
6 years.
6 years, yeah. Okay, well, I'll sign the motion. I've looked at your affidavit, it appears to be appropriate. And on occasion, what I do is if the petitioner does not have the proceeds to do it, I'll charge it as cost to the respondent. In this case, it doesn't seem like the respondent is in very much better financial shape than you are. Would you give that correct?
Only thing that's changed on this is he just purchased a new vehicle. That's the only thing that's changed on here.
Well, the only thing I'm doing now
Okay.
is filing a motion to let you file. So if you have something else that you want to put in your original petition, this is gonna be a self-help one, you're gonna do it yourself? Well, I doubt if he has a lot of equity in the car that he bought. You know, I could buy a jet too, doesn't mean I own much of it, you know what I mean?
Well, I didn't know if it would make a
It
difference
would
or
make a
anything.
difference. We'll hear
So
about
I
that.
just wanted to make sure everything was clear on it.
Is there any property much divided, or have you already got everything that you want?
Got it.
You already divided?
Yeah.
Well, let's just, I'll sign this and then y'all do the correct forms and I'll put y'all asunder real quick.
Okay.
Sounds like
Sounds
what both of you want to do, okay?
Mhm.
Okay, thank y'all very much.
Thank you.
We got the order, is there an order form that does it? I'll go ahead and have the order form electronically filed and then you can file your petition, okay?
It's not e-filed, so you'll have to sign.
Okay, well, I'll go ahead and sign the paper, okay? Thank y'all.
Thank
you.
Okay, yeah. Reliant Loan Servicing versus Ruby A. Nars Perkins, also known as Ruby N. Nars Perkins, also known as Ruby Perkins, and the Citizens Bank of Cumberland County. Okay, what do you got here?
Are you with Mr.
I'm saying with Mr. Backer, yeah. Judge Colton Givens on behalf of Citizens Bank of Cumberland County. Our motion today is for a supplemental judgment. Court previously entered judgment in our favor back in July in the amount of $33,700 and some change. Master Commissioner sold the property on November 1st, and I'm pleased to report that it sold in an amount sufficient to cover our first priority mortgage. We're asking for a supplemental judgment to recover our fees, costs, and interest. Adding that on to the principal judgment that was entered back in.
How much you asking for?
$40,000, 191.
Additional cost?
No, this is total. I can tell you what the additional is.
Okay.
As well. The additional is $4,435 in fees, $447.92 in costs.
What were the costs?
$447.92.
What would they be?
I'm not sure, Judge. That was
Well, send me a breakdown.
breakdown of the costs. Okay.
Okay,
Be
was
glad
there,
to.
were there supplemental liens or were there?
Yeah, there were multiple liens in this case, Your Honor. The plaintiff had a secondary lien. So the plaintiff filed for the foreclosure and then joined Citizens Bank of Cumberland County. So they're the priority lien holders. They'll get paid first.
Right.
But
They're gonna consume all of it.
no, there will be some left for the plaintiffs. But this sale has been scheduled at least 2 times. And the plaintiff's attorney come to my office the day before the sale. And not you all, the
Right.
plaintiffs. The day before the sale, gave us a check because they were planning on bidding on the property. And then called me an hour later and said, cancel the sale. And so Mr. Backer then contacted me and we rescheduled the sale after that. So I suspect there were additional attorney's fees that they're requesting in the supplemental judgment.
Well, how much is a plaintiff?
I will tell you that we have already prepared a motion and order for all of the fees and for everyone to be paid back. And we have sent that to both Mr. Backer's office and the plaintiff's office, and they've confirmed that everything looks fine. But the plaintiffs who actually filed the action, they'll receive $19,000.
So there's enough, was this real estate or what was it?
Was Reliant Home Servicing. I can't remember if that were a tax lien to begin with. No, they had a secondary mortgage. So.
Property
They
sold
won't
for
be paid before.
64,000. We were first priority with a principal of $34,000.
You were first priority?
Yes, we were first priority. The second mortgage holder is the one that initiated the action.
I got you.
It included us because
I
we
got
got the
you.
interest.
I'll sign your judgment.
Okay, thank you, Judge.
Your Honor, I've also filed the motion for order confirming, and I have their amount, which matches the supplemental
Yeah.
judgment that you're about to sign. And I have, like I said, this has been sent over to the plaintiffs and they agree with everything.
Okay, that'll be fine. Just submit it. We'll sign it. I was a little confused on who the initiator was there for a second. Okay.
Judge, in looking at the supplemental judgment that my office tendered, it looks like the judgment amount is blank. I can give that to you now or
The master commissioner, convince her of it and she'll submit it to me for signature, okay?
Okay, that'd be fine. Right.
She's the one that has the money.
Understood.
And if you see any problems in it, just tell me, we'll hold the judgment, okay?
Okay, thank
Okay,
you.
thank you.
Now, Your Honor, I do have the deed here, if I may.
Yeah, I can sign it and you can hold the deed, I guess, until the closing, right?
That's fine, yeah.
You Let's see. I filled your date in too. You gonna sign it today?
I'm going to sign it, thank you.
Okay.
They flagged me on my audits a couple times for not getting the search of their deed within 5 days.
Yeah.
Sometimes you just can't help that. They will come pick it up.
Especially when you have a foreign circuit judge that doesn't leave. It was over in the hinterlands. Okay. Okay. Okay, thank y'all.
Thank you.
Yeah. Carol Walden versus TLJ Enterprises of Kentucky doing business as McDonald's.
Good morning, Laura Morley on behalf of the plaintiff. This is plaintiff's motion for a trial date.
Good afternoon, Judge. You have Grant Grissom on behalf of defendant TJL. I have no objection to plaintiff's motion.
Judge, this is my first time.
Y'all finished all your discovery and you have instructions and list of witnesses, local rule followed to, or at least form. If it's not the local rule, I think my form probably asks for more than local rule does, so.
Your Honor, that's what I was about to say is this is my first motion for a trial date before you. And after listening to several of the motions today, I think based upon how you run your court, we may be slightly premature for a motion for trial date, given how quickly you set them. Your Honor, my intention with this motion for trial date is to keep the case moving. The plaintiff was ready to mediate this case in November. The defendants requested to cancel the mediation. There is one fact witness left. She is subpoenaed for January. The plaintiff has requested a corporate representative deposition. That request was made in early November. A corporate rep still has not been identified. And so we certainly want to keep this train on the tracks and moving forward, which was the intention.
Well, I'll keep it on track for you. If you've got someone that's resistant to providing you anything you're entitled to, you can file a motion, I'll sanction them. But I can, when you're ready to try it, 3 or 4 months out's a big time period here. because I don't tie things up, you know, and when they're ready to go, we go. You want a jury trial, obviously, in this thing, won't you?
Yes, and I anticipate a 3 to 4 day jury trial in this. Your Honor, how does your court entertain proposed agreed scheduling orders with pretrial deadlines?
We do, but you know, first I try to let people see if they'll go around, and then you don't have to wait till the next rule day. When y'all get off the camera here, I would suggest you call each other and see if you can reach an agreed order on scheduling deadlines, okay? And if you can't reach an agreed order, you can set something with me next Thursday online, or I can set something in between. You won't have to wait another month. So I would suggest both. Go ahead, Mr.
I'm sorry, Judge. I'm completely fine with working out an agreed order on deadlines. And we intend to get these depositions rolling as soon as the new year, Judge.
Well, our audio on some of these things has been really bad today. You know, I almost think that it has to do with the inflection of some people's different voices that just don't pick up as well as other. I've noticed that today. Maybe I'm used to just hearing my dialect that I have and understand it. I had an interpreter come there to the office one time. It was from Russia, and I asked her when I was still in the Senate, and I asked her if she had trouble understanding me, and she spoke English. She was Russian, spoke English with a British accent. I said, well, I have a Southern accent. I hope you can understand me. She said, no, sir, you don't have a Southern accent. You have a country accent. So I knew she was a little bit more sophisticated than I had to worry about, you know. Okay, well, I'll depend upon you guys to get an order together reasonable, and just know when you get ready, we can take this thing to trial pretty quickly, okay?
And Judge, may I ask you, what is your lead time, you know, for a civil trial like that? How far in advance do we need to reach out to you for a date? Did you say 3 months?
Well, I can do one. If you were ready, I could probably do one in 2 months, or I could do one in 3 months. It depends on how many days it's going to be, and we'll look at the calendar. We have rule days on Thursdays in order to keep Monday, Tuesdays, and Wednesdays open. You know, and then if we have anything that has to be heard, we use on Fridays. But of course, you know, when you get into December and sometimes early January, and then after that, you get into SEC tournament and other things that are equally as important. But we'll get you a trial. It won't linger forever. Just try to go along with me, work these things out, and reach a scheduling situation, and we'll move this case. Okay.
Wonderful. Thank you, Your Honor.
Y'all have.
Thank you, Judge.
Commonwealth, Kentucky, County of Monroe. Renoticed. Is that it? Does that conclude the docket? Do we have any confidential matters this afternoon? Okay, let's go off the record then.
We're 10 minutes behind on the jury.
Do what?
We're 10 minutes late.
Okay, let the jury